Please. The bone of contention is, in this case, is Annexure 5, which is a format of the certificate to be submitted along with the tender documents. This court finds force in the submission made on behalf of the petitioner that as per the requirement of Annexure 5, the signature has to be of the attorney or authorized signatory, which cannot be more than one for a tenderer, which in the instant case is a joint venture. This court also accepts the submission of the petitioner that signature of any director or shareholder or partners or any of the constituents of the in this Annexure 5 may also amount to a false declaration, as such person may not be the attorney or authorized signatory of the tenderer. This court also finds force in the contention made on behalf of the petitioner that in a similar tender, the petitioner number 1 who had submitted the bid was declared to be technically responsive. In this regard, a specific government has been made in paragraph 13 supported by Annexure 21 relating to tender number so and so. When the respondent railway have taken a stand to accept a tender in a similar nature from the petition number 1, there cannot be any justification for rejection of the present tender on a technical ground. In view of the aforesaid discussion, the court is of the view that the rejection of the techno-commercial bid of the petitioner number 1 by the email address so and so is unsustainable in law and according to the same is set aside in cost. Petition stands allowed.
Allah, Your Worship.
Wait, Your Worship. Item number 5, we have filed an affidavit that can be called on record
5.
for the Director of Agriculture
Okay. You're appearing for the director.
Yes, yes.
When did you file the affidavit?
today morning.
Why today?
There were some instructions that were awaited, so we had to file it in the morning.
It was not the understanding. We wanted to fix the matter next day itself. We gave adequate time so that the affidavit could be exchanged. Have you served copies on the other side?
Yes, sir.
Bring it.
Obliged.
May I please, Your Worship? In item number 61, there's petitions that filed on affidavit yesterday. So we need some time to file our objection.
61.
Item
I'm for the applicant, madam, the petitioner.
The application is for what?
My application is for modification of an order, madam, interim order.
You're the petitioner.
I'm the petitioner, madam.
What modification do you want?
Madam, actually, by that modification, madam, it was stated that the cattle market is under the provisions. The cattle market should get a license.
It doesn't matter. Doesn't matter. You need some time.
Yes, Lord.
On the prayer of Sri A.J. Hazarika,
Yes,
Learned Council, for the response number
10.
10, matter stand adjourned by
4 weeks, Lord.
2 weeks, madam.
2 weeks,
Also 4 weeks.
3 weeks to enable
Lord.
filing of
Objection.
objection.
Lordship, may I please, Lordship, item number 54 to 56, Lordship, is a contempt matter, Lordship. This matter, in terms of your Lordship, earlier Lordship, I need to file my affidavit, Lordship. Lordship, I'm paying for some more time to file the affidavit. Other side.
Yes, madam,
I am wait. Again, this time may be given, my already matter.
Lordship, I'm
on the
paying-
prayer of Sri P. Nayak, Learned Council, for the response number 1, matter stand adjourned by 2 weeks to enable filing of affidavit in opposition. 54, 55, 58.
of that.
Yes.
May I please, Your Lordship? I pray for listing of matter on admission, 3rd of May, ma'am.
3rd of
May, ma'am.
matter of which year?
Well, 22, ma'am.
Please, your lordship. CMT matter last listed on 14th pilot. After that is a part third matter.
Which one?
PMJ matter. PMJ University.
Okay, oh, that money laundering.
Money laundering. They have directed to till now they didn't give any date, my lord, for listing of the case. I have informed yesterday, my lord.
Okay, when do you want?
My lord, if possible, Friday, my
Friday, only for fixing a date or what?
yes, my
Okay, only for fixing a date. Friday cannot go for a hearing.
yes, my.
May I please, Your Honor? WPC number 1562/23. It was lastly posted on 23/23. Currently the matter may be listed on 10/5/23,
On 20th of March, what had happened?
28 March.
What had happened on 20th of March?
What is?
When the matter was last listed on 20th of March, you have said, what was the order passed?
Order passed for taking the steps. It is.
Have you taken steps?
A copy, copy certain.
You've taken step. When do you want? When do you want now?
Now I want 10/5/23.
Listing on 10/5. 10/5, there's a lot of time. Today we are only on 26. Why are you mentioning now?
The order pass that after 4 weeks, it may be.
No, why are you mentioning now? 10/5 is a long way to come. 2 weeks. Mention in the next week.
Okay, okay.
Yes.
With regard to item number 38, your lord, we have filed the affidavit today, your lordship, may be allowed to bring it on record, sir.
38, which matter?
38, your lordship.
Which was this matter?
Lordship. 38. Arbitration matter.
Arbitration matter.
Yes, yes,
Okay, bring on record.
most of it.
Have you served on the other side?
Yes, yes.
May please, Your Lordship. Lordship, I beg to mention item numbers 29 and 30, my lord.
29, 30
Item
years.
number 30, the private respondent is filing affidavit yesterday, my lord.
Hmm.
So I pray for 2 weeks' time for filing rejoinder.
Inform the other side.
Yes, my lord, we have taken the consent.
On the prayer made on behalf of the petitioner. List after 2 weeks.
Can a date be fixed, my lord?
List after 2 weeks to enable filing of rejoinder affidavit to the affidavit in opposition filed by the private respondent. Fishery matter, settlement.
Yes,
Yes, when do you want? List on, as
On the
paid
third
for
of
list on
18th of May, my lord,
15th of May,
18th, my lord, 1/8.
18th. Okay, 18th is a Thursday. 17th.
Oblige, my lord.
Also, item number 17. That has become infectious. Lord.
3A not learned counsel for the petitioner submits that by flux of time, the writ petition has become infructuous. Taxation was the Chaudhary. 3B Chaudhary, learned standing counsel, finance and taxation is present. Full stop. Para. Writ petition accordingly stands dismissed as infructuous. Interim order, if any, there is no interim order. I see.
Pass the lordship.
Yes.
Yeah, please, Lordship, item number 24 to 27
Hmm.
and 57, my lord. My lord, the engaged counsel, Mr. KB Upadhyay, is under bereavement, my lord.
Okay.
It may come on 15th or 16th of May, my
It is submitted that Sri KB Upadhyay, Senate Council appearing for the petitioners, is under bereavement. Para. List after 2 weeks.
On 15th of May, my lord, if possible, he's from
So-
Delhi.
Okay, is the Australian
My
Council.
lord.
List on 15th of May.
Yes.
Item number 24 to 27 and
57, my lord.
24 to 27 and 57.
Well, I have small prayer for listing of admitted amount matter, my lord. Two admitted amount matters.
When do you want?
My 3rd of May. Witness.
3rd of May, yes.
Wait, please, your honor, for listing on 2nd of May.
2nd of May is a Tuesday, I think. Why Tuesday? What matter?
Your honor, non-payment of
Contractual bills, not on Tuesday. Next day, 3rd, yes.
Your Lordship, I beg to mention item 59, Your Lordship.
59.
59. In this matter, Your Lordship, today I have received affidavit of opposition filed by the PNID department.
Panchayat.
Yes, Your 3 weeks time may be granted you file the rate.
On the prayer of Sri K. Meera, Senate Council for the petitioners, list after 3 weeks to enable filing of rejoinder affidavit against the affidavit in opposition of the Panchayat and Rural Development Department.
Oblige.
Yes.
Your Lordship, I beg to mention item number 77 of supplementary cause list.
Hmm.
My senior is currently unwell. The matter may be adjourned and taken after a week.
77. Who is your senior?
Jay Sharma.
Okay. Is it from the other side?
Yeah.
Inform the other side? No.
We haven't
You
informed.
have to inform the other side. We'll grant the adjournment, but without information, no. You would inform the other side. We'll adjourn when the matter is reaches. Who is there? M. Moore, MD Bora, ATDC. Tourism development. And from the other side, info. Yes, next, madam.
Okay.
I beg to submit for listing of WPC.
Listing of a new matter,
No, WPC, whole matter, 2020,
of which year?
2022,
22. When do you want?
10th May.
10th May, why are you mentioning now? Mention in the next week. Your mention memo will be misplaced, not now. Mention the next week, yes.
I beg to mention 78, 79. The actual settlement is going on, my lord.
78,
I want to
79, yes, what is it?
I want to withdraw this matter.
78, 79.
Yes,
Sri S.K. Roy, Senate Counsel for the petitioner, submits that in view of certain developments, he has instructions not to press this writ petition. Also heard Sri C. Goswami,
3 and 4.
also heard
Assam State Housing Board.
MS S. Sharma, Senate State Council, as well as Sri C. Goswami, Senate Council for Responsible 3 and 4. Full stop. Para. Writ petition accordingly stands dismissed, has not pressed. Separate orders, huh? Both 78, 79,
Same.
same order, Bilekuma.
but if occasion arise, my lord,
What liberty लिखी है? What liberty do you want?
my lord. The allotment process is going on. My lord.
That's a different cause of action, not required. Yes, next. Yes,
The illegal eviction from the Pokhari Parbaha Barpeta Satra, my lord. Just that I have filed debate before the deputy commissioner, then got yet disposed. My only prayer at this stage, my lord, only to direct the DC to consider my representation.
how is your writ petition maintainable?
My lord, I am a Khatiyan holder of the Pokhari Parbaha. And resolution has been taken by the management of the Barpeta Satra committee for cancellation of my mutation. But that part, the committee does not have. The cancel mutation can be only by the deputy commissioner or the revenue authorities.
No, we are not saying don't have a grievance, but can it be raised in a writ petition? Your grievance is against whom?
Again, Pokhari Parbaha is the management of,
Against the Satra Management Committee of Borpeta.
as well as against the deputy, because I.
No, that is not the deputy. You cannot bring in the deputy commissioner like this.
My lord,
This is a
deputy-
private dispute. We are not going to entertain this
my
kind
lord,
of
again,
dispute.
my illegal eviction, I raised the point before the deputy commissioner, and deputy has not disposed my that appeal. That.
Yes, madam.
Instruction
Well-
has not come, my lord. We have communicated. Otherwise, it's
We have grave doubts. We have expressed this doubt in the first order.
my lord.
Simply coming to this writ court will not help. Your remedy lies somewhere else. We will not say anything on the merits. You may have a good case, but not a writ court. You bring the instructions.
My lord.
On the maintainability, you bring instructions.
3 weeks time may be granted.
On the prayer of MSM Bormon Land State Council, matter stands adjourned by 3 weeks to enable her to obtain instruction.
Obliged.
My lord, take me, my lord. I did them directed to obtain instruction from the deputy commissioner. So what happened of my that petition?
Will not say anything else. Yes, next.
My lord, I'm extremely sorry, my lord, during delivery of the judgment, I could not be there, my lord, because of. I've heard the judgment, my
You
lord.
have
I'm
dismissed your case.
obliged. I've heard it, I'm obliging. So I'm extremely sorry.
Dismissed for non-prosecution.
Because of this Maligaon bridge, my lord, we cannot.
Where is Mr. Bhuya? Kazi matter.
Yes.
Mr. Mazumdar was addressing,
on legs. Meanwhile, we've received some instruction.
he's there or not, Mr. Bhuya?
is there.
What is this statement?
Yes, ma'am.
What is there?
Well, the second paragraph, he says, I'm a newly appointed Qazi, was unaware of the norms, regulations and acts. in
Oh,
the
he was a
beginning-
Kazi also.
Yes, my lord.
My appointment is not as a Qazi.
Your
And may
state,
not-
your statement.
He has signed, my lord, as MMR. He proposes as MMR and Kazi.
Mr. Bhuya,
My lord,
we are not jumping into any conclusion. We'll give you this copy.
my lord,
There's a statement of you,
my lord.
your client.
My lord, this statement was read over last time also before my lordship, my lord.
We have been handed over this time, just now.
My lord.
We don't know. You hand over a copy?
Lord, may I pray, my lord, let them file an affidavit, my lord, clarifying all these things. my lord.
Notice.
It's at the notice
Not
stage,
been
motion
issued.
stage.
Notice has not yet been
It's
issued.
at the
my lord.
motion stage.
Well.
Mr. Muzumdar is here.
Well.
The instruction shows that yes.
We saw you entering the room and you're thinking that what to do now. Some new strategy. So the statement is there.
Malam,
Let him be given a copy of the statement.
Malam,
Let him take instructions
Malam,
because this will have a different turn to the,
Malam.
if he's also a Qazi, apart from being a registrar, then matter would be different.
Lord, my lord,
Let him have a look at it
Uh,
and then think.
Sri D. Mazumdar learned AAG, assisted by MS S. Sharma learned DA, has placed before this court a copy of a statement of the petitioner in which there is an admission that apart from being a registrar, the petitioner had also, petitioner is also a Qazi and had executed and had solemnized on certain marriages without knowing the consequence that such marriages was amongst. In such marriages, a child was involved. Full stop. Para. Bhuya, A.R. Bhuya, learned counsel for the petitioner, however, prays for and is granted 2 weeks' time to obtain instruction. Para. List for motion on
15th.
17.
We'll have it on 22nd.
Malam,
3 weeks' time. Huh?
Malam.
my lord, interim protection and leave it.
Interim order passed earlier to continue till the next date of listing.
Oblige.
नाम क्यों नहीं है? नाम क्यों नहीं? Oh, in person.
Yes.
My lord.
In person की different.
This case, my lord, I need some more time for instruction. My lord, file is in the office of the chief ministers. As
Get
per my lord's
instructions,
my lord.
The allegations are very serious.
My lord, that is true, my lord. But the file is in the chief minister as for instruction, my lord.
Okay. Because Bucha,
Yes, my lord.
because Bucha learned, because Bucha petition in person is present. Para. D.K. Sharma learned additional senior ground advocate prays for some more time. Full stop. Para. In the interest of justice, matters to adjourned to be listed on.
After 2 weeks, my lord, any date.
But next time we'll be reluctant in granting
My lord,
adjournment.
it is in the process, my lord. It is not my lord.
It's on. Tell us.
Any date, my lord, after
10th
2
of
weeks,
May.
as per convenience of my learned friend.
12th of May. 12 May. Cause list to indicate that the petitioner is appearing in person.
But 2 numbers of grievances against the Director of Vigilance and Anti-Corruption has been there. That are not pending with the Chief Minister's office. Please give the direction to.
Let us have his, let him have the input.
Thank you.
Affidavit है लेनी. Affidavit है इसे.
My lord, I have been engaged on behalf of the director only to the extent of the opinion that your lordship's opinion that he has committed contempt. So I won't go into the merits. I will only address your lordship on that issue.
No, we'll hear you only if we want your assistance. We want to interact personally with him. There's no requirement of any legal assistance. He is a responsible officer.
That is there, my lord.
If he has got any problems with interacting the court, then is he fit to hold the office?
But
We'll have your assistance if you want, not at this stage. We
otherwise,
wanted to have personal interaction with him.
we have
Mr. Chaudhary,
that is up to certainly up to your lordship.
no, if there is any disability, then definitely.
I leave it to your lordship.
There's no difficulty.
I
think, on
absolutely
his
leave
part.
it to your lordship. That is your lordship's discretion, my lord. I'm the last
Yes,
person.
Mr. Chaudhary. Have a seat, we'll come to you.
My lord, in this case,
Have a
the
seat.
director has filed an affidavit, my lord. In the first part of the affidavit, he has expressed.
Where is the
his-
affidavit?
In the first part of the affidavit. my
Mr.
lord,
Sharma, we are not happy. Affidavit at least should have been filed yesterday, at least. We looked into the file, there was no affidavit.
এখনো extra document আছে? এখনো?
Requisition এখন দিছে না? Try to bring that.
Yes, I'm getting.
Yes, yes, Mr. Chaudhary.
Yes. If your lordship would kindly take the affidavit, my lord.
Hmm.
Now, please come to paragraph 2, my lord.
Paragraph 2.
Yes. Or my lord, please come to para 3 at page 355. That the deponent begs to state that by way of this affidavit, the deponent however most humbly endeavors and aspires to present a narration of the facts and events that led to this error of judgment on the part of the deponent, wherein the deponent failing to understand the real scope and reach of the Honorable Court's interim order dated 24/3/23, proceeded to inadvertently commit the offending action that potentially tantamount to circumventing this Honorable Court's interim order itself. The deponent most earnestly, however, pleads that violation that had happened at the hand of the deponent, but essentially owing to his misunderstanding of the scope of the Honorable Court's order, and it was not a deliberate and intentional attempt on the part of the deponent to circumvent the deponent's court's mandate. Deponent please, there was no mala fide intention. So now therefore he says, my lord, it was really a mistake on his part. It was not intentional. Now, having said that, my lord, now he tries to justify why he did it. That is where, my lord, in my humble submission, my lord, now he is, my lord, in prep. Now he has resorted to falsehood. Now, my lord will kindly come to paragraph 8. That the deponent, sorry, my lord, I'm sorry. Lordship will kindly come to paragraph 7.
358.
Yes, 358. That the deponent begs to state that on 4/4/23, the deponent had submitted an application taking casual leave for 6/4/23. However, because of exigency of service, the deponent could not avail the said leave, and that deponent had applied for, and as such, deponent was on official duty. Now he's trying to justify that he was attending office.
So was
Para
this-
8.
Was this an issue that he was not in office?
Yes, my lord. But there is an issue, my lord. Because he took leave, my lord. He was on leave on, my lord. He was on leave on 6, 10, 11, and 12. My lord, if necessary, we'll file and reply to this and bring on record everything.
But the version is that the leave was not availed to applied for.
Yes, my lord.
On this, if your lordship will.
No, we'll come back.
Anyway, my lord, that is an aspect lordship will go into, my lord, but prima facie, my lord, he took leave for 6, 10, 11, and 12. 8, para 8. That the deponent begs to state that the deponent working in the capacity of the Director of Agriculture Assam is required to conduct training, field visit, and attend various government meetings, thereby invariably leaving less time to attend these office files within the office hours. This necessitated attending official matters beyond the office hours on more days. Similarly, on 6/4, the deponent had to attend the aforesaid meeting till around 5 p.m. and thereafter deponent continued to attend his office related matter. It was at that time the nodal officer Madhuram Patiri had received a copy of email dated so-and-so from one of the recipients of the email so-and-so. The said email was issued by the World Bank in principle to proceed with alternate source of supply of seeds. Deponent called Baljit Singh over telephone to confirm receipt of the said mail, which was answered in the affirmative. Now he is trying to say, my lord, He did it because of, there was a request from the World Bank Authority, para 9.
One of the recipients of the email,
Yes.
that is. Who is Baljit Singh?
One of the, my lord, recipient.
No, who is he?
My lord, Mr. Baljit Singh is working in Riaz Society. He is as a agriculture specialist, my lord.
He's an official.
Yes, my lord.
Yes. Para 9, my lord, the deponent begs to state that the deponent, before proceeding with the issuance of supply order dated 6/4/23 for procurement of maize seeds from the alternate source from the selected vendors Assam Seed Corporation Limited, had also on 6/4/23 at around 6:15 p.m. discussed about issuance of issue with the state project director Akashdeep IS. Sri Akashdeep had also, based on email dated 6/4 issued by World Bank, had directed deponent to go ahead with the issuance of the supply order urgently, and had also suggested that formal communication from the World Bank and correspondence and approval for the same will be issued subsequently. Now, my lord will kindly come to that communication. It's at page 380. 380. This is the mail, my lord. Page 380. Here he has partly distorted, and thereafter he has suppressed another mail, my lord, which we are holding.
This we have seen on the record.
Yes. No, my lord will kindly see. Please come to the, on 27th, kindly down below on the bottom. Thanks for your mail and queries dated 27th of March as per the subject above. The project team has prepared the replies to your queries which are appended herewith. Now, this is, my lord, this was by the state project director. After the stay order was passed on 24/3/23. So there was already communication with the World Bank authorities, my lord, that there is a stay order of the High Court, what to do and what not to do. Maybe that he will have a better position to
This
explain.
email was addressed to whom?
Now, that is the thing. That is, it was to, my lord, the state project director. That Akash, that another IAS officer, he is not the person, my lord. Now, my lord will kindly see.
No, let us see the
Yes.
recipients of the email.
Now, it was from, my lord, one Beksor Chamslev.
No, that he is the, not the recipient.
No, Ashish Kumar Bhutani.
Kumar Bhutani, he is the SPD.
Yes, state project director.
And copy has been marked to him.
No.
Copy has not been marked
No.
to him.
Now, my lord, kindly see. Now down from state project director area society sent on Wednesday, that is by Akashdeep, my lord, on 5th of April, to, my lord, that World Bank fellow, then CC to so and so subject, seeking approval to procure seeds directly through ASCL and under APART. Now, this was on 5th.
No, was this in the context of the present tender or generally?
Generally, my lord, maybe generally. Well, whatever may be the context, since the concerned seeds are subject matter of, supply subject matter of proceedings before this honorable court, was it not incumbent, my lord, to inform or take leave from this honorable court? Even if you want to adopt any alternate mode of, that means, my lord, you will circumvent something and do something at your own whims.
Apart is another project, isn't it?
No, it's a process, same project, my lord.
No, apart is different. This is not areas.
Same project, no,
No, apart is different.
same project. Same. Right. Now, my lord, what I'm trying to show is, he is taking a stand that there was some communication from the World Bank Authority, pursuant to which, my lord, he had resorted to an alternate mode of procurement. So how does it matter? That was his understanding. Now, my lord, what I'm trying to say is, now he is relying on this mail. Pursuant to this mail, my lord, the decision to go for that alternate mode was given on 10 by the state project director. This is hiding from this honorable court.
This document is at page 390 of the affidavit.
My lord will kindly come to paragraph
390.
Then, my lord, let us test their argument, my lord. Please come to page 361 before I refer to their document.
This 10th April has reference to 6th April. Yes.
Yes, yes. He could have done anything only pursuant to this, not on 6th.
This has been addressed to whom?
This has been
This is
given
the-
by my lord.
This has been addressed to the director.
Yes, by
Only on
the
10th.
state project director on 10th, Akashdeep. Before 10th, he could not have done anything. Even if we go by the story that there was a pressure from the World Bank and the communication was with the state project director, not with the director, my lord.
And the orders are issued when?
6th. If at all, my lord, if at all there was any authorization from the state project director, it was on 10th. Now, my lord, kindly see why I'm saying they come up with half-baked facts. Page 361.
361.
Page 361.
Yes.
Para 10. That the deponent begs to state that thereafter Sri so-and-so project agri specialist put up a detailed note on the evening of 6/4/2003 in the concerned file of the nodal officer, which was thereafter further put up by the nodal officer so-and-so before deponent on so-and-so, along with prepared supply order to be issued to the selected vendors of the Assam Seed Corporation. That the deponent begs to state that from the perspective of the farmers' welfare, etc., now they are very কথাটো ক'ত ক'লে 10 তাৰিখৰ মূলৰ কথাটো উল্লেখ কৰিছে নে ক'বাত 390 বুলি কৈছে না দুটো Now please come to para 17, my lord.
Para?
Yes.
Para?
Para 17.
Oh, page 364.
Page 364. What is that?
4.
That the deponent begs to state that on 10/4/23, the deponent received an information from the Standing Council Agriculture Department that the present litigation came up for consideration before the Honorable High Court, wherein submission have been made by the learned counsel for the petitioner that the deponent has committed violation of the Honorable Court direction. Deponent thereafter immediately took some legal advice, and deponent realized that he has committed an error of judgment by failing to understand the real and actual jurisdiction of the Honorable Court's interim order. Deponent immediately on 10/4 issued a notification cancelling. Now, where is the reference to, my lord, that email dated 10/4/23 of the, my lord, state project director? My learned friend stood up and said that it is page 392. Yes, that means there is no candid disclosure of facts. That itself is enough to, my lord, to initiate contempt proceeding against the alias contemner, my lord. But there must be some statement in the petition.
Where is the cancellation? Which page?
Yes.
Page 390.
1 second, my lord. Actually, it was served few minutes back. I haven't read the whole thing.
39?
390.
No, 390 is the
393.
direction. 393. Okay. It was on 10th.
And hedu thaka boli je kole 10/4 or page 390.
সেইটো তো নহয় বেলেগ সেইটো বেলেগ 390 সেইটো বেলেগ
390 cancellation order hai.
No, 390 is the communication to the director
Yes,
and 393 is the cancellation.
Cancellation. Now, my lord, this 390 annexure 9, where is the mention in the body of the affidavit, my lord, that he also received a communication? My lord, if at all there was any communication from the state project director, that because of urgency and all.
No, there was a telephonic from one Baljit. You act on telephonic instructions. Yani?
72.
You act on telephonic instructions.
Yes, my lord. Yes, my lord. I got the telephonic instruction.
You act on the telephonic instructions.
My lord, somewhere, sometimes circumstances comes to, I have to work on telephonic conversation, my lord, because my farmers are suffering.
Circumstances is more important or more, their priority is more than a court's order.
No, my lord, that I have violated, my lord, that
You are admitting of violation.
no, my lord, that was my error of
You
judgment,
seek
my
proper
lord.
instructions. You have a counsel with you, senior counsel.
With your lordship's permission.
My lord,
See, we have not seen the affidavit, what you have stated.
Yes.
See, this
Hey,
is the
even my lord,
contempt proceeding.
served hardly 15
We
minutes
are,
back.
we are contemplating whether to initiate contempt proceeding. We can inform you that unless your action is deliberate and intentional, then only we initiate. If you can make out a case that you have done it without understanding or without any intention, then we may not, we can drop this proceeding here, but your conduct,
no, my lord.
we have not seen the affidavit. Affidavit has been placed for us just now. 3-4 things have come up. There was an email
My lord,
of 6th, which was with regard to a general procurement policy. It was not in connection to the present tender, number one. Number two, the email was not marked to you. It was not sent to you. It was sent to the SPD, State Project Director. State Project Director gave an official communication on 10th. You're admitting that.
yes, my lord.
You say that some Baljit had given you a telephone instructions. You thought that it was circumstances which was very necessary. And on 6th itself, you issue the orders. There is an allegation on 6th you are on leave. You have said that you have cancelled the leave. There is also an allegation that 10th also you are on leave. The cancellation order is of 10th.
Yes, my lord.
What have you said of 10th?
My lord, entire proceeding not started on 6 itself, my lord. हमने 3 तारीख को एक communication किया था, my lord.
Not in Hindi.
My lord,
Aren't you an IS officer?
yes, my lord, I am.
You are not conversant with English language.
Yes, my lord.
Then why have you resorted to Hindi?
My lord, on 3rd of April, my lord, our assistant nodal officer initiated.
We don't understand Hindi. We are not required to understand Hindi in a court.
Sorry, my lord. My lord, on 3rd.
And yes, we would have understood if somebody else would have come, not from an IS officer.
No, my lord, that apology, my lord. My lord, on 3rd of April, my lord, my assistant nodal officer initiated a note regarding we need to procure through alternate source of procurement. My lord, on the same day, my nodal officer also initiated. Then we have written to SPD Areas Society, my lord. हमारे को we need to procure from alternate source of alternate source, my lord. After that, my lord, SPD initiated proceedings and SPD communicated to the World Bank, my lord. And because OPIU is a part of Area Society, my lord, on behalf of Area Society, we are working, my lord. And our problem was that, my lord, in Area Society, we are procuring at different rate. And in Assam marketing, Assam Seed Corporation rate, my lord, that was different, my lord. And entire initiative was discussed with our senior officials also, my lord. Then it was decided, my lord, we have to approach to World Bank. And under World Bank policy, my lord, procurement policy, there is a provision, my lord. That's why we have moved this to World Bank, my lord. And when we got the email from World Bank, my lord, I have confirmed it to same time on the to Mr. Baljit also and SPD also. SPD is Mr. Akash Deep, my lord. And he
Where is your statement that you have confirmed from the SPD?
Yes, my lord.
Where?
That is here written, my lord. I have written here, and he also confirmed, my lord. My lord, this is.
Now, giving all benefit of doubt to you, there was a stay order from this court.
My
Let there
lord,
be a communication from the World Bank or whichever bank. Will you act against an order of this court?
No, my lord.
Don't you think that it was at least incumbent upon you to seek leave of this court or
Yes.
inform this court?
Yes, my lord. It is. I have not understood that, my lord. That's why I have not approached, my
Mr.
lord.
Gyani, you're not a layman. Don't say that you have not understood the consequences.
My lord,
You have not undergone the training.
my lord,
Have you undergone the training or not?
yes, my lord.
You don't know the basic idea of a court proceeding.
My lord, I have I have gone through the,
It doesn't appear so.
my lord, it was not, intention was not there, my lord. My lord,
Your bona fide is not coming out.
My lord, to kindly come to page
I'm not seeing
372.
any
my lord.
bona fide in your submission.
my lord,
That is the problem.
my lord, my
Otherwise,
lord.
we don't have so much of time. There are many other matters.
Yeah, understood, my lord.
We want you to be here in the court.
My
At
lord,
the same time, maintaining the dignity and majesty of the court is of paramount importance for us.
yes, my,
Otherwise, the system will go.
yes, my lord. My lord,
We need time to go by the affidavit. Yes, Chaudhary, we have not seen the affidavit.
And we would also like to file and reply. my lord.
You should have filed the affidavit at least yesterday. Give us the time. He may not be, we can absolve him of any liability. But we have to need some time to go through this affidavit. But Professor, what Mr. Chaudhary have shown, we're not too much.
Your Lordship
happy.
permits me, Madam. He has perhaps not been able to explain himself. May I just take 5 minutes of your Lordship?
No, we'll hear you if that it be. What is it? Just in 2 minutes, what is it?
My lord, he really is my lord, I'm not saying it only because he is my client. As an officer of the court, I am also interested in upholding the majesty of this honorable court, my lord.
That we know, that we have full confidence.
My lord, if I may explain the situation. The one fact which has not been, even now he was unable to express, it is his lack of expressiveness. One basic fact which has not been brought to your Lordship's notice till now is, after extensive research, there are materials which I can place. In the state of Assam, 30th of April is the end date, the last date for maize seeds to be sown. Now, let us look at the sequence of events. On, my lord, 10th of February, the first writ petition
I
is.
think you're going into the factual days.
I'm
Please don't address on the factual.
no, I'm
We are
just.
not too much interested in what was the
even
leading
I'm-
season, what
no,
is the sowing season.
I'm not.
What is the
I'm
urgency?
absolutely not entering into the marriage file. I will just place the orders, dates of the orders. my lord. This fact has a relevance. That is why I pointed out, my lord.
No, 30th may be the end. You come before this court, explain it to us.
Yes, he should
Take
have
an
done
order,
it in a
take the
different
leave,
way.
Go ahead.
Yes,
So what is this kind of
in
thing?
fact, my lord,
There are two orders you may be aware of.
absolutely.
First, we had said that it
My lord, that is-
consider.
That is
consider
why.
this what? Consider with this disability of the petitioner. On the same ground, again, what is this kind of?
It was a
The
complete. my
intention
lord,
from the very initiation appears to be to somehow.
I
give it to
appreciate,
somebody.
I absolutely appreciate. I have meticulously gone
We'll
through
have
each
to
of.
day after tomorrow.
My lord, fine.
You can file an affidavit by tomorrow.
Yes,
Tomorrow
I will
is,
file tomorrow.
Mal.
or if
If
you
the
would say,
lordship kind, can I
you will
take
say on
leave, my
Monday?
lord, Maheshwar?
My lord, next week, my lord, because of my new assignment, I have some difficulty.
This is also a new assignment. Appearing for a LS contemner. You have not done so.
I'm sorry.
You have not done so. Appearing for an LS contemner. Have you ever appeared for an LS contemner?
I have.
You have.
That is why I would like to, my lord, start off by tendering an unconditional apology. And I would have liked to place some facts which.
See, last time we had made it very clear. Unconditional apology means an apology which is a sincere apology.
It
It comes from the heart.
It comes from, it is
Not
coming from,
by writing in the paper, piece of paper, place it before.
it
the
is
court.
coming from the heart.
Let us see
My lord,
how sincere
fact,
it is.
how he became a victim of circumstances, that is what I wanted to place.
2nd of May, is it okay? Or you will not be there?
My lord, next week, your lordship will kindly excuse
Oh,
me.
then day after tomorrow.
Day after. Day after.
Day after tomorrow is okay.
My lord.
Mr. Chaudhary, where is he?
He was, he has a.
I heard Sri Ken Chorelan, senior counsel for the petitioner. Sri what is the full name of your client? A.L. Gyani. Anant Lal. Anant Lal. Sri Anant Lal Gyani, Director, Agriculture, is personally present pursuant to the order passed on the last occasion. He is also represented by Sri I. Chaudhary, Senior Counsel. Also heard Sri B. Chaudhary, Standing Council Agriculture Department. Whereas UK and Ireland Senior Council has appeared for the
number 5.
spot number 5. Sarah. The it appears that the director has filed an affidavit. Pursuant to the last order, an affidavit was directed to be filed. Full stop. However, it appears that the affidavit has been filed by the Director, Agriculture, only today. Full stop. Para. In that view of the matter, place this case for consideration on, or for further consideration on 28/8. Full stop. The Director, Agriculture, would remain personally present on the next date.
We are deeply obliged.
Yes, what is this? Item number 6. GST, what is this?
The senior is on leg.
Who's this? Kyle?
Yes, sir.
Where is he? Cancellation.
Cancellation of what has your lordship, I am relying on your lordship will kindly see. That
For
we-
non-filing of returns or what?
Lord, no, your lordship, there,
What?
they say that your lordship, there are some, we have not disclosed some certain incomes, your lordship, and for that, your lordship, they have imposed penalty, your lordship. Then your lordship, they have, your lordship, freeze my accounts, your lordship.
Oh, this is not those series of matters where because of non-filing of returns,
Nothing to do.
there
with
is some penal action against you.
my account. Freeze, your lordship. I later on filed an appeal, your lordship. Appeal is pending, your lordship.
What is the status of the appeal?
Appeal is still pending, your lordship, but I am relying on an office memorandum issued by that.
Let him come, we'll have it after some time. Madam, call your senior. Okay. Sri B. Chakraborty, learned CGC submits that an affidavit in opposition has been filed, which however is not on records. Full stop. On the other hand, Sri Sahiwala, M. Sahiwala, learned counsel for the petitioner, prays for and is granted 3 weeks' time.
12th of May.
3 weeks' time to file a rejoinder affidavit. Full stop. In the meantime, that the affidavit filed by the department be placed on record.
And till then the arbitration.
No, lordship. Already we have assured that we will not, we are not, on last occasion, the lordship has recorded lordship. Let it come, nothing will happen.
That may be recorded now.
It's already recorded. last-
There's an undertaking.
Hello.
Undertaking, have a subsidiary.
And till 12th of May.
No, lordship is, he may not be worried about lordship.
Para, Sri Chakraborty, the learned CGC, has undertaken that no adverse action will be taken till the next date
Madam.
fixed in this case.
Deeply.
Don't say adverse, no further steps. It's not a question, Edward. No further steps will be taken.
Here, your lordship. The
Yes,
petition,
where is he? Kyle was here.
that is seven, that is item 7. This is
Yes, 7.
Item 6.
6, your lordship.
6. There is an appeal pending.
Lordship, what happened?
What has happened to the appeal?
Lordship, appeal is time barred. He has not filed an application for condemnation of delay. That is my information, Lordship.
But that will have to be dismissed, your lordship. That has not been dismissed.
No, if you don't, dismissal will only be on technical ground
Lordship,
because of non-filing of delay condemnation.
lordship.
Why don't you file a delay condemnation?
That
Since
instruction,
you have already availed the remedy of
Lord,
filing of an
Lord.
appeal,
lordship.
make it a genuine, regular appeal,
Lord.
file the delay condemnation. If it's not condemned, then you have some other
Lord.
remedy.
Lordship.
I think that will be the best course.
Lord.
We'll have it after 4 weeks.
After 2 weeks, your lordship. In the meantime, I will.
On the last occasion, this court was apprised regarding filing of an appeal by the petitioner SSC. Full stop. 3 para. 3 SC Learned Standing Council, Central GST, however, submits that the appeal has not been taken up for consideration as the same is time barred and there is no application accompanying the appeal for condemnation of delay. Full stop para. 3 S. Bothakur, Learned Counsel for the petitioner, however, submits that he will instruct for filing necessary application for condemnation of the delay. Full stop. Para. It is observed that as and when that in the event such an application is filed, the same may be considered by the appellate authority in accordance with law. Full stop. Para. List after 4 weeks.
Much.
8, your lordship. The petitioners, your lordship, before this honorable court, your lordship.
Yes.
Here they have come, your lordship, apprehending eviction, your lordship, and what has happened here, your lordship, they are in fact, your lordship, some of them are occupying Nadipatta land, some are riots, your lordship,
Occupying what?
not occupying, your lordship, they are owning. your
Owner.
lordship. Owner.
You say occupy will have a different quality.
Yes, sir. I'm sorry, your lordship.
That will be more dangerous than grabbing.
Owning and occupying, your lordship, in fact, and in what
Owner
is,
in possession.
now what has happened, your lordship, as of now, your lordship, there is no state of eviction as such. But your lordship, what has happened, your lordship, way back, your lordship, the petitioners, your lordship, some of the people, your lordship, residing in the same area, your lordship, were evicted, who are also, your lordship, patta holders, your lordship, and those people
Which
came
part? Where?
in Kathar, your lordship. Korimganj, your lordship. If your lordship-
Eviction for what purpose?
Eviction, your lordship, the purpose, no notice, nothing, your
You
lordship.
know, there has to be either you are encroachers
No, I am not.
or
we are
there is some plan for building something or a
nothing,
park.
your lordship. That's why, your lordship may kindly come.
Yes,
to-
madam, what is it? Any instruction?
No, your lordship. Although in para 6, my lord, he has mentioned a table containing the, petitioner has mentioned a table, my lord.
Appeal.
A table has been annexed by
number
showing the
37.
type of land and proof of their documentary evidence, my lord.
Yes.
But that's is annexed here.
The
That is,
original-
we need to take instruction.
Two documents I have annexed, your lordship, but it is very difficult to translate from your lordship.
Lordship,
That's why,
page-
your lordship.
Page 37, only the type copies are annexed, your lordship. The
No,
original
those are those
documents-
objections we will have, will consider. But what is the purpose? What is the actual state?
Exactly, your lordship. It's nowhere stated in any of the pleadings, your lordship.
No, why don't you take the instructions?
Yes, sir.
Is there any actual,
Time for instruction.
okay, you take instructions.
It's an apprehension notice of notice for it, my lord.
Heard 3S Bothakur, Learned Counsel for the petitioners. Also heard M. Borman, Learned State Council, as well as MSN Bordola, Learned Standing Council Revenue Department. Full stop. The Learned Counsel for the respondents, however, submits that the writ petition has been filed only on an apprehension and our apprehension without stating the reason for the alleged eviction. In any case, both the learned counsel for the respondents pray for and are granted 3 weeks time to obtain the instructions.
Deeply obliged.
I'm deeply obliged.
You have copies
The
I
extra
will furnish.
copies may be furnished.
and let extra copy of the writ petition be furnished to the learned counsel for the respondent.
May it please your lordship. The last occasion, my lord, the honorable court was pleased to grant time for obtaining instruction. Before that, my lord, may I explain it? Because this is, we are engaged in the, my lord, work of, my lord, manufacturing of sleeper, my lord, since 1991, your lordship. And for that, my lord, because we have to manufacture sleepers for railways only, your lordship. So railway are allotting land to us. And accordingly, my lord, in 1991, my lord, 3.09 acre lands, it was allotted. And it was governed by my lord, different circulars. And as on today, my total 5 circulars are in my lord, force, your lordship. And as per the agreement, your lordship, that your
Any
lordship will find
instructions?
it.
Yes.
It is free of, if the additional
But
land,
aren't you required to pay license fee?
I am giving your lordship, as per circular. your
Lordship,
lordship, as
this
per
is
the-
for additional 0.80 acre of
this is
land.
additional
Lordship.
land, and it is.
For
based-
this, they are not have not
Page
paid.
36, your lordship will see. It says, my lord, for the purpose of loading and unloading. In the interest of railway, if the additional lands are, my lord, required, it is free of cost. We are not saying, even assuming, my lord, they want to take, my lord, license fee, it has to be as per railway board's
Where is the circular?
circular. First, your lordship, page 36, then I will come to.
No,
circular.
come to the circular.
Circular,
statement.
that your lordship may kindly come to page 222.
222.
222, triple two. And I am taking your lordship directly to relevant page, page 224.
222.
Circular date is 7/9/2005. And relevant page, my lord, page 224. And fixing of land value, your lordship has got it, my lord. The
Number?
market value would however be required to be taken to serve the base value for working out rental fee payable. This shall be fixed on the basis of the land value of the surrounding area as on 1/1/1985.
Hmm.
As determined from revenue authorities and for or the following manners. My lord, this question, my lord, came up before this honorable court, my lord. Which, my lord, and this honorable court that your lordship will find at page,
No, where is that additional area for loading, unloading is the given free
that
of,
page 36, my lord.
free of cost?
Page 36, my lord.
30?
6, my lord, the type copy of my agreement. It starts from 28 and page 36. Clause number 7, my lord. That of occupation and use of railway land. The contractors request for making available reasonable area for the railway land for his work site of his stores, labor, apartment, stacking place for material or any other purpose connected with the work will be considered and provided by railway free of charge on such terms and conditions that may be prescribed by purchaser to the purchase officers. But I'm saying, well, even if they are not willing to give me free of charge, it has to mean as per circular, master circular of railway. And that question came up before this honorable court in another proceeding. That I have annexed, my lord, and this honorable court has set aside their demand and matter was remitted back for consideration on the basis of master circular. That judgment, my lord, may kindly see page
Yes, but
237.
Lordship, first lordship, that case he is relying lordship. In that case, the land is situated at Palaspuri Revenue Circle, but here the lordship petitioner as well as the plot of land is in Katihar lordship. Even the impugn order issued by the railway officer of Katihar, who is West Bengal. So first point is that lordship, so far this jurisdiction point is there, lordship. Secondly, lordship, I have submitted the instruction, lordship, page 11, lordship, starts from page 11, relevant portion, clause 8 at page 17, lordship. This is a new circular of railway, lordship, page 17, clause 8, lordship. Dispute resolution. I have page mark, lordship, that instruction, page 17, this is clause 8 of 410. This is a new. Case starts
Now,
from page 11.
why Guwahati High Court?
My lord, because agreement was executed by General Manager Maligaon Guwahati, your lordship. This, I am executing work as per the agreement between the parties. That your lordship will see page.
You are from Calcutta.
No, my lord. My lord,
You're not from Calcutta.
my lord,
West Bengal?
my office, land was allotted at Jalpaiguri under NF Railway, your lordship. Agreement was executed by General Manager Maligaon, my lord. That your lordship will see.
Your company is registered where? West Bengal.
My
Yes,
lord.
your lordship.
Company is registered, but NF work was allotted by NF Railway, your lord.
Impugned order is issued from Katihar Division Lordship.
That is true, but agreement was on the basis of that agreement, I am executing the work.
Is
It
the
is-
agreement the cause of action?
My lord, because on the basis of that, they are charging, they are allotting my land, my lord, everything. It is not that they are
Order which was impugning is from Katihar.
through your lordship. It is under the jurisdiction of.
You are
NF Railway.
registered in West Bengal, cause of action arises in Katihar.
My lord, but my lord, agreement was executed by NF Railway and they are working under the jurisdiction of General Manager NF Railway. Ultimate authority is General Manager, your lordship.
Then why not New Delhi?
My lord,
Why not New Delhi then?
because my New Delhi is.
Why not?
Through your lordship, but 226, my lord,
Why not New Delhi?
through your lordship, but
If we
here your
accept your
lordship.
logic, then every matter of central government has to be in New Delhi.
But my lord,
It's been governed by, monitored by New Delhi.
my lord, ultimately, my lord,
Why Guwahati?
General
Why,
Manager will give direction to Katihar, your lordship.
and general manager will be given direction by whom? By the Ministry of Railways?
Yes, Lordship.
My
Go
lord,
to,
but-
go to New Delhi then.
My lord, that point, your lordship, but my lord, in my humble submission, since my lord,
On territorial jurisdiction, we are going to dismiss this.
my lord, 226, my lord, your lordship may kindly see the
So
agreement.
some cause of action. Wholly or in part.
My lord, the agreement and
Only
their
because
clauses,
it favors
he has
you,
to
you
comply.
come
with-
to this court.
It is, my lord, page 36, my lord, it says free of cost, and this agreement was executed by General Manager NF Railway Maligaon, my lord. And he is working under the jurisdiction of General Manager Maligaon, your lordship.
Where is the impugned order?
Impugned order, my lord, may kindly see at page 229, your lordship. He is officer under NF Railway, your lordship, page 229. NF Railway Katihar.
The address to you at Siliguri, you are at Siliguri,
My office.
and from Katihar it has been
Yes, Lordship.
originated. You come to the Guwahati High Court.
Page 126, you also will see awarded by North Frontier Railway Maligaon.
Hmm?
Page 126.
That is only the contract is signed by
That,
the,
on the basis of that contract, I am executing work.
but land is there, Lordship, in West Bengal.
And ultimate authority is, my lord, General Manager, because I am complying with the terms and condition of the contract.
We have to
Your lordship,
interfere. We have to interfere with an order passed by the general manager.
by that, my lord, DRM Katihar.
Then
But my lord, I am relying on the clauses of my lord agreement
you'll also be, will you be precluded from relying on the clauses if you find in the place with jurisdiction?
My lord, that question may be kept open, your lordship. I will satisfy my lord that your lordship has jurisdiction, my lord, under 220. That I was not, my lord. Because on the last occasion, instruction was only for whether, my lord, this support-
We don't find jurisdiction
my
here.
lord, in that case, my lord, I will satisfy, my lord. I think, my lord, your lordship has.
Had it been the case that agreement is signed elsewhere, but this impugned order is issued in the state of Assam by some authority in Assam, we are concerned with the impugned action for which you have approached this court. And you are also not a resident of Assam. Your place is at
Because of that,
Siliguri.
my lord, it was filed here. In fact, my lord, if your lordship will see clauses of the, I have to comply the.
If we do not go by the strict mandate of the CPC in a writ proceedings, we go by the CPC, where is the cause of action? Tell us.
My lord, cause of,
We go by the spirit, definitely.
my lord, that impugned order may be
When
read
when can you address this court on the jurisdictional issue?
Friday, your lordship.
Not this Friday, next Wednesday.
Next Wednesday it is.
Hard.
Can it be, my lord, then ninth, your
Go
lordship?
ahead.
On ninth, your lordship.
For the petitioner. Whereas MSB Sharma, current CGC is present for the railways Full stop. Ms. Sharma has placed before this court written instructions and has also raised the issue of maintainability on the lack of jurisdiction. On the issue of jurisdiction, Sarah. Shri Goel, council prays for and is granted time till
9th of May, your lord,
9th of May.
because second I shall be out of.
On not 9th, 10th of May. To address this court on the issue of territorial jurisdiction. Full stop, para. Please content.
Till then, my lord, some protection, my lord. Till then.
What protection?
No, Lordship,
Otherwise,
there
they
is
will
no
execute.
such,
Till then, my lord, there are, if I fail, my lord, my lord,
What is
automatically.
the protection you
My
want?
lord, that impugn the order, my lord.
Lordship, that is of January, till date,
So
nothing there.
what kind of protection?
No coercive measure may be taken. At least that,
Only for recovery they are trying.
My
What
lord.
coercive measure?
Yes, Lordship.
my lord. That
If
may,
there is anything, you come before us.
my lord, page.
Obliged, Lord.
Page
That is-
229, my lord.
there is
Some
no-
protection, my lord, otherwise, my lord,
What kind of protection? Tell us.
my lord, this impugned order may not enforce, my lord, till
So
10,
what is the difficulty you are facing tomorrow?
my lord.
What is the immediate
They are insisting, my lord, this is a letter given. to us.
letter is given? What, has any coercive action been taken against
But
you?
they will deduct from my running, this is a letter issued by them, my lord. Till then, yeah, my lord, some protection, my lord,
No, no,
otherwise, my lord,
no.
it will become infructuous, my
Will not be infructuous. It's only a money matter.
lord.
Yes. Next.
Obliged, Lord.
Deep love.
May I please, Your Lord?
Yes.
My lord, these matters relate to my lord. Petitioners are running, my lord, vending units in the Rangapara railway station, my lord. My lord, here there was a round of litigation, my lord.
Hmm.
I have mentioned there was a writ petition, my lord, earlier filed regarding some dispute of my lord areas.
Hmm.
My lord, finally, this was headed by the Honorable Single Judge, my lord. Then there that area issue was, my lord, headed. Thereafter, my lord, there was a writ appeal, my lord. In the writ appeal, it was decided that we may be continuing the vending units and an opportunity may be given to us for running our stall, my lord, stalls. Thereafter, my lord, there was a hearing, my lord, and after that hearing, without any valid reason, my lord, we have been asked to vacate the places, my lord, and of course,
There have been litigations, I think.
Yes.
Now.
my lord,
What has happened to those litigations
my lord,
regarding platforms, vendors in platform?
my lord, there's a
My lord,
serious, my
regarding
lord.
one of the petitioner yesterday, the matter came, my lord. There is a single judge of the coordinate bench under the catering policy of 2017. My lord, quoting that, my lord, the learned single judges held that, my lord, there is no scope for renewal. So the licenses were cancelled and, my lord, they were asked to participate in the fresh tender process.
My lord, may I just give a backdrop, my lord?
You have the order passed.
Yes, my lord, I
There
have
is an
also,
order, page 185, my lord. Page 85 is the
185.
185. On the earlier round of litigation, my lord,
No, the order passed yesterday.
yesterday,
my lord, the order passed with the coordinate bench.
not yesterday, my lord, sometime back, I have also gone through, my lord. There are some aspects, my
These
lord,
are the
that,
matters, my lord.
my lord, there are some aspects,
These-
which were not, my lord, brought into notice, my lord.
My lord, these are licenses, my lord, who have been issued licenses, my lord, prior to 2017. And under
lord,
the
may I-
new catering policy, my lord, there is no scope for renewal and the government, my lord, is intending to tender. And accordingly, my lord, these licenses were terminated and they are asked to participate. But what they are trying to, my lord,
My lord,
pray is,
I
no,
may,
lord, they wanted the
I may
renewal.
make
They're praying for
make my
renewal.
submission before, my lord. My lord,
Yes.
my humble submission before lordship is this, my lord. We are, my lord, running this shop since long, my lord. My lord, 2016, 2010, there was a policy. My lord, before 2017, that there, in that particular 2010 policy, my lord, there is scope of renewal. Then,
Okay.
yes, my lord. Then, my lord, there some litigation came up before the Honorable Supreme Court regarding that part, whether it can be renewed or not. My lord, there is a landmark judgment, my lord, on this part. I'll just refer, my lord.
Hmm.
There, my lord, the Honorable Supreme Court said a vendor who will be having only one shop will be allowed to run, not multiple. That minors, there some categories were made, my lord, like that Dalas, wheelbarrow, like this, some refreshment rooms. My lord, 2016, Honorable Supreme Court said one license may be renewed only for 1 unit per person. So that was in 2016. 2017, my lord, policy only, my humble submission, my lord, only
You
to
are
buy.
referring to the judgment by Honorable Justice Roy.
No, my lord, this is I just in its nutshell, my lord.
Siddhi Quorum, some, what is the name, some catering?
Catherine.
What is the quorum?
My lord, my lord justice was
Yes,
there, my lord.
yes.
Yes. Commuter was also there, my lord. My lord, after this particular judgment, my lord, after this judgment, my lord, 2000 policy was only brought to bypass this order, my lord. How, my lord? 2017 policy do not have any renewal for the existing licenses, my lord.
2000 which policy?
2017, my lord, there's a
17.
policy. And in some requisition, my lord, we have also assailed that because it is, my lord, policy is not good. That in
What
that
is
matter.
the outcome?
2017, my lord.
What is the outcome?
This honorable court, single bench said that policy is good.
Then,
My lord. Now, my lord, 2020, after 2017, that is only the relevant part I'm bringing, my lord. 237 page, my lord.
okay,
237.
237.
Yes, up to 2017 it is okay, my lord. There is no policy, but also in the policy there was some provision of phase manner, whatever, my lord. Now 2031, sorry, my lord, 231 page.
Yes.
231, there is a subsequent circular, my lord, commercial circular by the same authority, my lord. 2022. It is circular number 22 of 2017. It is past 20, my lord. Here, my lord, the judgment before lordship, that was taken into account. Say in spirit of the honorable court judgment, that in terms of those, my lord, after 2017 policy, my lord, this is post 2017 policy. Yes. Here, my lord, this circular says that there would be renewal, there will be renewals. But in terms of the said judgment. Now, my lord, I'm just putting in very short manner, my lord.
The 17 circular says that
There-
in compliance with the direction of the Honorable Supreme Court dated 29 January 2016, there will be renewal.
There will be renewal in phase manner, my lord. It's
Okay.
one that is there, my lord. Now, my lord, may I just bring to your
But you have
lordship
just said that there was some other policy which has been upheld by this court. What was the?
2017, my lord. 2020, 20 of 2017 circular. But
This is a later circular, 22.
yes, 22, but it was not challenged, my lord, at any point of time.
22 is not, there is no requirement of challenge because 22 is in compliance of the judgment of
Yes.
the Honorable Supreme Court.
Yes.
So
It-
as on today, 22 is operating,
Operating, my lord, that is
not 20.
not 20 is also there, 22 is also there. So after 22, my lord, we understand that by the spirit of the honorable High.
How do you reconcile, Mr. Gupta?
Yes, my lord.
In the
my lord,
last
just-
case, 22?
my lord, before that, only one paragraph, my lord.
Yes.
Just page 120, my lord.
120. 120.
120, my lord. Their affidavit, only this much I have to pray. Earlier case, my lord, they filed an affidavit by the railway on 2020. My lord, at paragraph 9. It is said, my lord, that with regard to the statement made in paragraph 7 of the read, is and this, my lord. Next page, 121, not equal to 5. It is pertinent to mention here that several correspondence have been made into the licenses for clearing of outstanding due, but no response has been received till issue of formal notice on 2018. Due to non-payment of outstanding dues, process of renewal could not be initiated. This is their stand in 2020. The process of renewal was initiated by Rongya Division subsequently in terms of commercial circular number 22 of 2017 issued by the Railway Board in light of a decision of the Honorable Apex Court. So this is their stand, my lord. Well, subsequently, yes, some renewals were also made. I have given a, for instance, I have given one annexure also, my lord. Agreement, my lord, that is at page 14, my lord.
This circular 22 you have brought on record by this affidavit. Annexure C.
Yes, my
Annexure
lord.
C is the circular 22, isn't it?
Yes.
Annexure C.
Their case, my lord.
No. Annexure, circular 22 is annexure C.
22 no, 17.
My lord, earlier case in the affidavit, it was annexed. my lord.
Okay.
My lord, at page 232, I would like to show, my lord, after 2017 also there were renewals at 2021.
Who?
To 232, my lord. For instance, we have other also knowledge, my lord. But some other agreements were also, my lord.
This is dated August 2021.
Yes. So if you it should be that case, my lord, cannot be, my lord. New question.
Mr.
My lord.
Gupta, how do you reconcile?
My lord, the circular of 2017, there is no 2022 circular.
No, he's saying circular number 22.
My lord, circular number 22, my lord, was in respect of 2010 policy. My lord, the judgment relied on my friend was discussed, my lord, the copy which I have given of the coordinate bench, my lord. That judgment was discussed by the learned single.
But that we have understood.
And it is
But
not
in,
applicable.
but in the circular of 22 of 2017,
My lord,
which you have issued on 5/3/2017.
Yes.
my lord. No, that was pertaining to 2010 policy.
But
The
post
licenses
2007
which were issued in 2010, my lord, that circular was applicable only to them. Here in the case of the petitioners, my lord, the licenses
When
already,
did the new policy come?
my lord, 2017, my lord.
Which
It's at page 210.
on February, my lord. February, no? On the month of February.
After the coming of the new policy, my lord, there was some, my lord, the circular dated page 210, my lord, it came on 27/2/2017. The new policy came on 27 February 2017.
And thereafter the circular.
And my lord, that circular was pertaining to 2010
No.
policy. That circular
2007.
was,
March
that circular
2007.
dated,
Not together, Mr.
my lord, the
Have your seat,
circular
we'll come to
dated,
you.
my lord,
We'll come to you. Have
Yes,
you
yes.
have your seat.
Yes, my lord.
my lord, the commercial circular dated 22 of 2017, which was issued in terms of the Supreme Court judgment, my lord, that was pertaining to 2010 policy. The licenses issued under 2010 policies, my lord, they were permitted renewals. My lord, here the case of the petition, the license period has already expired in the year 2009. And my lord, pursuant to the coming of the new policy of 2017, there is no scope for renewal, my lord, and the government intends that, my lord, the process should be by way of a tender, which the railway has permitted them to
See,
participate.
Mr. Gupta, there are 3 aspects.
My lord,
If you take 210 and 231 together,
my lord,
210 is of February
my
2017.
lord,
Circular, commercial circular of 20 of 17.
17,
Thereafter, 22 has come
my lord,
on 17/3/2017.
my lord,
No doubt this circular is with respect to a judgment by the Honorable Supreme Court. If you read the first line,
my lord,
notwithstanding any provision in the catering policy of 2010,
my lord,
it starts with a non-obstante clause.
yes,
And earlier catering policies, only those minor catering catering unit license would be eligible for renewal. So this is the policy now. How can you say that a later policy, same commercial circular of 2020 will be of 2020 or number 22 will not be applicable?
my lord, may for the moment, my lord, we peruse the speaking order, my lord, which was passed pursuant to the orders by the London Division Bench, my lord, page 184. My lord, there it was
184.
184. Page 185 is the speaking order.
Yes.
My lord, it says, my lord, allotment of license for minor catering stalls is to be done as per existing policy, that is catering policy 2007. Para 9 of this policy states that licenses are to be allotted by open competitive tender
and there is no scope for renewal as per this policy. This policy is of open competitive tender is in congruence with the Indian Railways aim.
Where is the judgment of the honorable
That
division
was
bench?
discussed, my lord, on the next page, my lord. May I
Let us
complete,
see the division bench.
my lord?
Has it covered this aspect?
My lord, page 174.
174.
Page 174 is the relevant portion, my lord, wherein my lord, the honorable division bench has refused for renewal, my lord. My lord, may I read from the last paragraph, paragraph 10. Page 184. We are unable to accept the said submission for the reason that all that the interim order provided was that as long as the appellants are required to pay the when fees they would be paying, it is in the interim at the existing rate, but the interim order did not preclude the respondent authorities in any manner to act upon the discretion not to extend the licenses and also not to accept the when fees. All that the interim order provided was that the when fees should be accepted at the existing rate and not at an enhanced rate. Although a stand was taken in the affidavit by the respondent railway authorities that because of the pendency of the court proceedings, the licenses could not be renewed or extended, but the said stand would be also be unacceptable in as much as there was no restraint order in any manner from the court during the proceedings, disentitling the respondent authorities from extending the license. So therefore, my lord, the liberty was given by the, my lord, the division, Leonard division bench, and thereafter, my lord, we have given them an opportunity of hearing.
What was the issue before the appellate court?
My lord, my lord will take the order passed by the learned single judge in the first round of litigation at page 163. My lord, page 164 is the operative part, my lord, the first round of litigation.
Just a minute.
Paragraph 19.
Just let us see what was the issue?
The issue is, my lord, at page 164. That is the operative portion, my lord, the order passed by the single judge.
Then they had challenged the demand for demand notices
Yes.
for area license fees.
Yes.
Then what was the finding?
The finding, my lord, paragraph 19, page 164. This
164.
court would also take note of the fact that by virtue of the interim orders, the petitioners are continuing to vend, irrespective of the fact that presently they have not renewed their licenses. It is the opinion of this court and accordingly clarified that the rights of the petitioner to vend is dependent upon the licenses given by the railway administration, and since the renewal allotment, the petitioner would have no right to vend. Accordingly, the railway administration would be within their rights to take appropriate actions as per the existing policy. Subsequent to that, my lord, we have passed the order, my lord, page 166. Page 166 is the order, my lord, subsequently passed after the order by the learned single judge, my lord, wherein we have directed for closure of the unit as the validity of the license period has expired on 10/12/2009 itself. Lord, page 166, order dated 8/2/2023.
Right. Then
And then, my lord, they have preferred a writ appeal. My lord, in the writ appeal, my lord, they have challenged and prayed that they should be allowed, their license should be renewed.
this writ appeal 87 is against that judgment.
Yes, against that judgment. So, my lord, there the prayer was for the renewal of the license. my lord.
21. Is it 23-1? Correct, you are correct, 153. And then division bench has said what?
Division bench, paragraph 10, my lord,
Page?
page 174. At the bottom, my lord. We are unable to accept the said submission for the reason that all that the interim orders provided was that as long as the applicants are required to pay the when fees, they would be paying it in the interim at an existing rate, but the interim order did not preclude the respondent authorities in any manner to act upon their discretion not to extend the licenses and also not to accept the when fees. All that the interim order provided was that the when fees should be accepted at the existing rate and not at the enhanced rate. Although a stand was taken in the affidavit by the respondent railway authorities that because of the pendency of the court proceedings, the licenses could not be renewed or extended. But the said stand would also be unacceptable in as much as there was no restraint order in any manner from the court during the proceedings, this entitling the respondent authorities from extending the licenses. Be added this may, the factual aspect that remains is that the appellants continue to pay the vent fee as the existing rate, and the respondent authorities continue to accept the same, leading to an equitable situation of there being an implied extension of the licenses, as no proactive measure was taken not to allow the appellants to continue with the vending business. My lord, in paragraph 14 thereafter, if the appellant pay all the arrear amount as an enhanced rate, being the difference between the enhanced rate and the existing rate, the situation as today would be as if the appellants had never approached the court and there was no interim order, and they readily agreed to pay the respondents the entire dues at the enhanced rate, and they actually have paid it. If that is the situation, we now leave it to the respondent authorities in the respondent railways to take their decision as to what they would have done had the appellant paid the vent fee for the entire period at enhanced rate without raising any dispute, and accordingly we also leave it at their discretion to do the needful as they would have done otherwise. In doing so, the appellants we also given an opportunity of hearing to arrive at an effective reasoned decision between the parties. Till any such reasoned decision is arrived at, the appellant would be allowed to continue the vending business, but with a clarification that the payment of the vend fees would be at the applicable enhanced rate for the interim period. Now thereafter, my lord, this order was passed, the speaking order was passed at page 185. That speaking order, my lord, page 185.
After the division bench, is there any scope now?
So the
My lord, we are agree. My lord, that is why, my lord, I am just in a, my lord, 2000.
Matter has been adjudicated.
My lord,
The core issue has been adjudicated. If you are agreed by the division bench, you cannot again come back to a single
lord,
bench.
2000, my lord, 2000, just, my lord, 2016, my lord, judgment was based on, my lord, that was based on the issues of livelihood, my lord. Livelihood.
No,
Now-
no,
yes,
under-
no, yes,
we have
my-
understood there are background facts, but
Yes,
when the division bench has passed the judgment, where is the scope for a single bench
Okay.
against?
the honorable division bench has my lord, that observed that they may be, we may be given an opportunity to be heard.
At best, we can issue notice. You are praying for an interim order, we cannot. Unless you put to challenge the observation of division bench, first round litigation, then had gone to a division bench. Issue is the same ultimately. These are all obstacles.
My lord, the speaking
When
order,
issue notice, you file affidavit.
So for the second concern, may I
They are two items.
my lord, one prayer I have, my lord, otherwise, the third party right may not be created at this.
Third party right, what tender?
Because tender will be floated, my lord, in a third party right.
You
will be-
participate in the tender process.
My lord, there will be some, there's some that issues, my lord, because finally that has to, my lord, livelihood
There,
issue.
there has been changes everywhere.
Yes,
You cannot stop a change.
true, my lord,
At the
but,
beginning, there is friction, but that is the way of life.
but 2016, my lord,
You have been
judgment,
running, you have been having the fruits of
yes.
public system. Now let there be a competition.
2000,
There is nothing which will preclude you from participating in the tender process.
if your lordship
You
goes to the
participate.
2016 policy, my lord, this was only, there, I will not repeat again, my lord.
But Mr. Hazarika,
Yes.
is there any vested right that you continue till perpetuity? These are public properties.
But my lord,
Everyone has to be given an opportunity to compete.
2020, when they filed an affidavit, my
We'll
lord,
come back.
yes.
This is the same matter, the next matter, but there are some aspects, with all respects, my lord, which perhaps was not placed.
So then it can be a matter for review of the
No, no, I'm not,
division
on-
bench
I
order.
I am not at all on that. I would not
Some
even,
matters not placed.
no, I'm
What is
not,
the
on-
law?
I'll take this, I'll take the first writ petition for the pages would be similar, but the page numbers. May I just place for the satisfaction, I'll try to persuade my lord to take a different view. On certain aspects,
The key aspects are,
No, at best, we can issue notice.
very well, my lord, may I try? May I
Now try
to-
for what?
May I try to persuade, my lord,
For,
for different view?
no, we are issuing notice. we
My
said.
lord,
We don't want notice to be issued.
Lordship takes a call, but may I just point it out?
What else can you expect?
There are aspects, my lord.
No, what else do you expect
fundamentals-
today?
The fundamentals, the fundamental stand was 2017 policy does not call for renewal. Rather, it goes for tender.
Mr. Bonik,
that
Mr.
itself is
Bonik,
wrong.
We are at the motion stage.
A
We're at the
protection-
motion stage.
Protection from your lordship would mean a lot. Therefore, I'm addressing your lordship on that point. He
On a-
tried.
We
May
are
I
praying
try?
for an interim order.
He tried, my lord. He tried his best out. May I try? If I go back home thinking that at least I tried to place what I thought of.
You have tried through Mr. Hazarika.
He tried well, my lord.
No,
May
no,
I
you have
point
tried
out?
even harder.
2017 policy.
We'll
which they
say you have tried.
But 2017 policy,
No, no, inclined after division.
well,
bench.
this division bench was a different platform, you know. Different bench, a different platform.
We still think that the order of the of the Supreme Court could have made things something else, but we are bound.
I understand, but there may be a way out. That's what I'm trying to point out, you know.
See, the order of the Honorable Supreme Court was followed in a circular of 2022.
I'm not on that.
But unfortunately, in the recent judgment of the division bench, those aspects were considered and a judgment has been passed.
So far,
Under those views, it is absolutely difficult for us.
so far as 22 is concerned, I'm not even addressing that. But they took a stand earlier, consistent stand all throughout.
No,
and now
and,
they take a
and,
third
and,
court.
only because of the Supreme Court judgment, we are something. But otherwise, we are not against the policy of going for tenders. That is the normal thing. You have to give everybody a chance.
But it is not like that in the policy at all. It's something
No
else in the
question of
policy.
Policy says that you give a chance to all.
Well, the
There
policy,
cannot be any right for a right.
page number 217, only one
for-
page,
for-
if I may
for
refer.
Perpetuity, no.
If I may refer page number 217 of the first case itself, of the first case. That only one page I'll refer.
200,
217 of the first case. which my
217,
friend had argued.
217.
217. What does it say on the existing stuff? The people who are flying on the platforms. Clause 6. I'll read, 6, 1, 2, 3, that's all. There should be no cooking on platforms at suburban stations, and for other stations, there should be efforts to progressively reduce cooking on stalls and trolleys on the platforms, except for items which could be prepared for so and so, so and so. 6.2 is relevant. No new humcha or alike shall be allotted. However, trolleys, humchas already allotted may be continued on selective basis. Pausing for a moment, it calls for a selection, which one to continue, which one to go for tender. This aspect is not even brought into before your lordship. I read further. In order to reduce congestion, they should be made area specific. The selected person who's to stay, care should be taken not to place them near FOBs, right on board, the free boarding is comes space, or doors or trains. Preference should be given towards providing them at the ends of platforms so that general service coaches and unreserved passengers have easy access to them. Such trolleys, comchas must have adequate availability to low price Janta Khana. My lordship, the entire scheme of 2017, the earlier circular, which is in force, rather, and all courts have taken view of that, it says otherwise. It says that those who are existing, you make a selection. Once you have made a selection, take a call. Which one to stay, which one to go for tender. Those two stays could not be near FOBs, doors or things. They should be in ends of platforms so that general people who travel to general stays can have access to them. Now, what does it say on the stalls, on the structure of the stalls? I go one door further. Gradually, all old catering stalls should be replaced with compact modular stalls of superior quality material to ease congestion on the station platforms and circulating area and improve the aesthetics, durability, and convenience for maintenance. It talks further that the module of the stalls has to be changed. It does not say that do not make a selection on one sweep. You say everyone to go. Their stand is wrong, and because of this, that they had made a selection, they issued the first one at page 95. The first one is 95. There cannot be a sweep removal. There must be a selection preceding the removal for tender. I would jolly well participate in the tender in a given case when they say they took a selection on their own. I did not participate there, and they say, no, yours one has gone for tender. Very well. That is not forthcoming.
What is 95?
Page 95 of the first petition. I proceed from where my friend has concluded. 95.
This was the notice issued to us. This notice said, your application for renewal of license being processed will be renewed subject to the condition of payment of area license fee. This is 8th of November 2018. Why do they say so? Because they have made a selection that we are to stay. This is not forthcoming from them. They had made a selection that is not before your lordship. Therefore, they say, we'll renew you, please pay up. So on the selection, I survived. I did not fall under sweep of tender. Next comes when they demand again at page 69 or 103. I take 103 for a moment.
This, what is the basis of your submission?
The basis of a submission
Why do
is
you say that the selection process was done? After which Maya Ghosh was one of the beneficiaries.
I would place it this way, Milord. 2017 policy was in force. In terms of
This is which station?
this is Rangapara.
Rangapara-
We're coming to that, Milord. 2017 policy, once it comes into force, clause 6.2,
No, Mr. Bonik, are you trying to submit that this notice was given only to few of the vendors and not to all?
this notice was given to those who had not paid the area fees.
That is it.
That is
There's no
genuine.
question of any selection at that
But
time.
once they say in November 18,
You
that is,
cannot just borrow some words of a circular.
no, at the end
and,
of the day, at the end of the day, they have to show a selection was made. That on what selection basis, who to stay, who to go for tender. This has to be there, Milord. In absence of that, they cannot, they're taking a stand randomly, they will sweep away everything under 2017 policy. There is no scope for renewal. There is a scope for renewal. 6.2, 6.3 is categorical on that. And they stand page 121, 126, 127, and 118. I specifically said, they take it a stand.
Pardon.
Minor-
Each other
minor.
Learned counsel for the, as well as three, as Bonik, Learned counsel for the petitioners in both these writ petitions. Full stop. The petitioners are aggrieved by the action of the railway authorities in going ahead with a process for allotment of spaces in the railway platform for vending by way of a tender process, by way of tender. Full stop. The case of the petitioners is that they have been in the business of vending for a long period of time. And if their cases are not considered, irreparable loss and injury will be suffered. Full stop. The petitioners have also submitted that under the existing policy, there is a scope for considering the case of the petitioners by making a selection amongst such stakeholders. On the other hand, H. Gupta, Learned CGC, appearing for the railways, have submitted that the present two writ petitions are offshoots of earlier litigation in which a division bench of this court has also passed a judgment in WA 90 of 2023. And in view of such facts and circumstances, there is hardly any scope to reopen the issue. Full stop. Not para. He further submits that the ultimate issue which has been raised in this present petition has been substantially decided in the earlier round of litigation, which had culminated in the order passed by the Honorable Division Bench. The aforesaid aspect of the matter would be considered for issue notice returnable by 4 weeks. H. Gupta Learned CGC accept notice on behalf of all the respondents that extra copies of the writ petition be served upon him during the course of the day. Full stop. The learned counsel for the petitioners have prayed for an interim order of para. Though this court is not inclined to pass a blanket interim order, comma, it is observed that any action taken by the authorities in this matter shall be subject to the subject to the outcome of this petition.
Grateful Lordship. If Lordship may observe one more line, if I may pray, that they issued a notice to hold a meeting on 20th of March, but the backdoor they held it on 14th of March by the record. Before the date, they held a meeting in the closed chambers. That is by their record, which we have annexed. That's on record. On record. That the observation that my statement was there. We have challenged it.
Okay, we will have it. Have you put it on affidavit?
Yes.
We'll consider it. Mr. Gupta,
And I'll have to take
take instructions on this.
8186. It's there.
Next. The Sakya, what is this?
My lord, this petition, my lord, Patakan, my lord, the petitioner has rent out a house, my lord, to a company, namely the Sarada Realty Private Limited, my lord, in the year 2010. Then, my lord, for running their branch fees. In the year 2013, one of its client has chosen an FIR against that company, my lord. But the petitioner has no knowledge about their business matter, no any relation matter. After losing that FIR, the police has seized the house, my lord, seal. Since 2013, the house is in locked and sealed. House is in fail condition, my lord. In the year
Yes, madam.
Like to take instruction, my lord, the stage of investigation and whether there is any necessity of keeping that
How
house
do you
under
keep
the
a house under lock and key for 10 years?
9, 10.
Only because some illegally, and this is all
It's
white collar crime,
my lord.
not a murder scene or any. It's only documentary evidence. You collect the documents,
Then that can be, still may be open. I'll have
we issue
instruction.
notice, third Sri Amsekya. Senate Council. For the petitioner, full stop. The petitioner claims to be the owner of a two-storied building at Birasipara town. Full stop. The Birasipara town, full stop, comma, the first floor of which was given on rent to a company. Full stop. The said company was entangled in a criminal case being Bilasipara PS case number 337 of 2013 under section 420 406 IPC. Read with section 4/5/6 of the price sheets and money circulation within bracket banning practical act 1978 full stop. As a part of the investigation, comma, on 10/5/2013, comma, the house in question was seized. On so and so 25 comma, the articles of the house were taken away by the investigation agency and the house was sealed. And the first floor of the house was sealed. Full stop. The was sealed, which is existing till today, full stop. The petitioner had approached the authorities for for de-sealing the house in question, which has not been done, as a result of which the instant petition has been filed. Full stop para. Issue notice returnable by 4 weeks. M. Borman,
All the respondents.
Learned State Council accepts notice on behalf of all the respondents. Let extra copies be served upon her by tomorrow.
Obliged.
May I please, Your Lordship.
Yes.
Lordship, here in this case, Lordship, petitioner number 1 is a absolute owner of a particular plot of land, Lordship. And petitioner number 2 is a daughter of the petitioner number 1. Petitioner number 1, Lordship, he intending to transfer this plot of land by way of executing a gift deed to the petitioner number 2, Lordship. As such, Lordship, he was applied for NOC, Lordship, from the Deputy Commissioner's, Lordship. Lordship, kindly come into case 20, Lordship. This is the acknowledgement received. Here, Lordship, it is reflected that stipulated time period is 30 days. And he was applied on 17/12/2022, Lordship.
Yes.
I have to take instruction.
Why the delay in NOC?
I have to take instruction.
When did you apply?
Lordship,
17/12/2022.
Stipulated time is 30 days, Lordship. And it is showing, Lordship, is a fake.
Or I hope that it counsel for the petitioner who is aggrieved by the inordinate delay in issuing NOC to the petitioner number 1, who has intended to transfer a plot of land measuring 9 bigha, 2 katha, 17.9 gachas to his daughter, who is the petition number 2, by a gift deed. Full stop. The said NOC was applied on 17/12/2022. And as per the statutory prescription, the time allotted for granting such NOC is 1 month. Full stop. Para. Issue notice returnable by 4 weeks. MS.
1 and
M.
3, I am in.
Burman Leonard. State Council accepts notice on behalf of respondents.
1 and 3, my lord.
1 and 3.
Others two are named by party.
MSD has a recurrent standing council. Revenue Department accepts notice on behalf of respondent number 2. Let extra copies be served upon the Learned Council for the respondents by tomorrow. That steps be taken for service of notice upon the respondent numbers 4 and 5 by registered postpaid AD. Steps by tomorrow.
Obliged.
Why have you made parties by name?
Lordship, yes, because Lordship, the petitioners personally meet and talk with the Lat Mandala circle itself. But till date, Lordship, they are not pursuing this file, Lordship.
Maybe. Before Lordship, my lord, he was the deputy general manager of NRL, my lord. Whatever, my lord, on the way back on 2021-28, a complaint was filed before the committee, my lord, this internal committee, my lord, of sexual harassment of workplace, my lord. And notice was issued to him.
Against him?
Yes, my lord.
Against your client?
Yes, my lord.
Then
what happened, my lord? Thereafter, notice was issued to him for appearance, my lord. By the time when the FIR was also filed, he was taken into custody, my lord. So he was in custody for more than 2 months. And while he was behind the bar, my lord, they have conducted the inquiry ex parte, my lord. So I was not participating in the inquiry, my lord. And ultimately, a report was submitted, my lord, inquiry report. On the basis of inquiry report, subsequently, token notice was issued, my lord, before development proceeding. And we sought to file an appeal because as per the act.
but in the first round, is it required to give you an opportunity?
Yes, my lord, because it will abide by the service rules. Whatever procedure laid down in the service rules,
Yes,
that has to comply with it.
But your participation will come only at the time of departmental proceeding.
No, my lord, because it cannot, the inquiry stage also, because
Let us see the wordings.
What is your lord?
Yes, sound very. Very. Sexual workplace.
Section 11, my lord.
Sexual harassment.
Also, I can take my.
We have the. Come to silo. Come to silo. Get up on silo. We have the book.
Or slowly I can read, my lord. Your lordship.
No, we have that book. Yes.
Lordship, I kindly come to section 11, my lord. That the procedure has been laid down.
Yes.
Section 11 says subject to provisions of section 10, internal committee or local committee, as the case may be, shall where the respondent is an employee, proceed to make an inquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent. No such rules exist in such a manner as may be prescribed. So I'm governed by service rule, my lord. Service rules, the notice has to be issued, my lord. Already notice was issued, but I could not find my reply because I was behind the bar.
No, the inquiry which has been contemplated by 11, has it been conducted and over while you are in the bar or the decision was taken to go for an inquiry?
No. Inquiry was, their decision was taken for Gorakhpur inquiry, my lord, by the internal committee, my lord.
Yes.
And they proceeded with the inquiry. They issued a notice to me for appearance. I took a time for filing my WS, my lord.
Okay.
By the time I filed my WS, I was inside. So I could not appear before the inquiry, my lord.
Your grievances on the later stage. During the inquiry, you were not heard because you are behind the bar.
Yes, my lord.
Not because of the decision taken by the internal committee.
No, I could not participate in the inquiry, my lord, because I was behind and I could not cross any of the witnesses, my lord.
Perhaps you have a point, but internal committee, there is no requirement. I think.
Because they say that to make an inquiry into the complaint in accordance with the provision of service rules.
You are correct there.
Because naturally, my lord, my presence will be required, my lord. If I have to cross-examine the witnesses, whether
No, that we may agree with you, but in first part,
otherwise they have clearly stated, proceed to make an inquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent. It's very clear, man. So the service rules clearly says that notice has to be given to me. I will be entitled for cross-examination of witnesses. I have to find my WS. And normal service rules proceedings, my lord.
okay.
Now, what has happened, my lord? Department the proceeding was initiated, and that has been stated by this honorable court, my lord, in a writ petition, my lord.
Yes, then now.
Then, but I have in that said, because actually what happened, we file an appeal. Because there is a provision under section 18 for filing an appeal before the appellate authority.
Now, what is your grievance now?
The appellate authority has been nominated as a payment. As a result, my appeal could not be disposed of. So I am, your lordship, since they have not nominated any appellate authority, so your lordship, I am praying for that. The lordship should exercise our judicial review, since the order is apparently illegal. There was an ex parte order behind my back and inquiry.
But you said that the department proceeding is under stay.
They, my lord, that on basis of the inquiry report, they have initiated another department. Because they took it as a misconduct. If it's on the basis of the report submitted by the inquiry, internal inquiry committee, they have proceeded with a.
Let us see the impugned order.
Your lordship will find that inquiry report, your lordship will find that.
No, the impugned order.
Yes, then that is under challenge, inquiry.
Page.
Here is your lordship. It starts from page 36, man, the next 6, man. Finally, your
What
lordship.
about the earlier order passed by this court?
Oh, passed by this court. That your lordship. That your lordship will find.
If you come to the order of 10-5,
Yes, my lord.
your appeal was already rejected earlier.
No, appeal was not rejected. It was returned back. Since they have not notified the appellate authority.
You come to the order of this court at page 95,
97, my lord.
95,
95, my lord.
the second paragraph, third paragraph.
The
Petitioner
petitioner
counsel-
submitted that challenge on appeal. So the petitioner accordingly submitted an appeal. Not rejected actually, my lord. It was returned back. It is wrongly stated.
However, appeal was rejected.
Not rejected. No, not rejected because they have not nominated the appellate authority. It was not rejected. It was returned back. Since they have not nominated the appellate, your lordship, kindly I can The order dated, your lordship, data dated can be clearly say that it was returned back. That is 24/2022, my lord. Because they have not nominated appellate authority. Because appeal is a matter of right, my lord. It is statutory appeal, my lord.
But don't you think that the cause of action, which was there in the earlier writ petition,
Yes, my lord.
2961/2022 is exactly the same?
No, cause of action is that because of for nomination of the appellate authority for stay available. Because I haven't challenged the finding of the inquiry officer, my lord, in that writ petition. That's why I'm coming.
In this petition, what are you challenging?
And challenge the report, my lord. The ICCI report, my lord. So it's just go through the club together, my lord. That is my prayer, actually. Notice may be issued, my lord, at this stage, my lord. Basically, I'm challenging the inquiry report submitted by the internal committee, my lord.
Does see an Annexure 6, 1911,
Yes, my lord. Annexure 6, page 36, my lord. That is the inquiry report, my lord. By the ICC, my lord. And the recommendation is to take action of sexual harassment as a misconduct in accordance with the provision of the service rule. Page 50, my lord, the operation department.
how do you challenge this? On what grounds?
It was expert, my lord. Your lordship, because even a
What
different
is the requirement of law?
requirement of law is that they should hear me, my lord, without hearing me. When
On
I
an
said,
internal committee, it's,
but the procedure has been laid down on section 11, my lord.
let us see. Let us see.
Section 11 says, my lord. Subject to provision section 10, the internal committee or local committee as the case may shall where the respondent is employed, proceed to make an inquiry into the complaint in accordance with the provision of subject. In accordance with the provision of subject applicable to respondent. The service will provide for issuing of notice, examining of witnesses in presence of otherwise, there is no point of issuing notice to me, my lord. Before proceeding in the inquiry, they have issued a notice to me for appearance, my lord. But since I was behind the bars, so I could not appear, my lord. That is admitted fact. An inquiry was conducted behind my back, my lord. Because
Kotoki, learned counsel for the petitioner who has put to challenge a report dated 1911.
1911.
This was of 2021.
That we have said is because of that, actually we have filed an appeal. Appeal was, they were not notified as on today, my lord. Other organizations have.
1911 report dated 1911-2021 submitted by the internal committee which has been constituted as per the sexual harassment of women at workplace within bracket prevention, comma prohibition and redressal bracket close act, comma 2013. Third bracket, hereinafter called the act. Full stop. The case of the petitioner is that in respect of this same incident, comma, the petitioner was arrested in a police case being Golaghat case number 813 of 2021 under section 354 dash A capital A oblique 370 of the Indian Penal Code. And during his detention, comma, the inquiry was held by the internal committee, culminating in the report dated 19/11/2021. Full stop. The petitioner has also submitted that the departmental proceeding which has been initiated pursuant to the recommendation of the internal committee is already the subject matter of challenge in a pending writ petition being WPC number so and so. Full stop. By referring to section 11 of the aforesaid act, comma, it is submitted that there is a requirement to proceed in accordance with the service rules applicable to the respondent. And in the instant case, comma, it has been submitted that no opportunity of hearing was afforded as the petitioner was in custody during the said period. Full stop. Para. Issue notice returnable by 4 weeks. NRL, anyone? No. That steps be taken for issuance of notice upon the respondents by registered post with AD. Steps by tomorrow. CP is already stayed.
CP statement.
So there is no
No,
need
it may
of
be,
list along with WPC 2961 of 2020.
We are on a very limited compass, my lord, here. Otherwise, it is an insurance claim. No dispute as to facts as such. The only thing is the insurance company asked us to produce a succession certificate. The succession certificate, because of its the judicial procedure involved, it takes some time. Accordingly, my lord, it took us around 4 months' time. By that time, my lord, the claim is closed and they are now refusing to reopen it, even though we have submitted the succession certificate. At this stage, my lord, I'm praying for notice only.
Oriental,
There is no standing counsel. There are some panel counsels.
Oriental has got a life insurance also.
No. No, my lord.
What insurance claim was it?
This is a motor vehicle master policy, my lord. Some death
No,
claim
what-
was, some
what-
death claim was entitled to, my lord. He was entitled.
Why succession certificate? Somebody has passed away.
My lord. Yes, the son of the petitioner passed away. Succession certificate is, my lord.
There is no adjudication.
No certificate, my lord. They simply asked us.
No,
to
you
submit a-
you did not approach a tribunal.
No, my lord.
It is not required to be adjudicated.
No, no, my lord. It is
Why?
only, there is no dispute, sir. When we submitted our claim, they said that produce a succession certificate. Because succession certificate took some time to obtain, my lord.
So how much do you get?
My lord,
Where is the adjudication?
amount claim to 15 lakhs, my lord, under the master policy. There is no dispute as to the sum, as of now at least. If they dispute, my lord, of course, we have to go to the consumer court or the civil court.
Not
Yes.
consumer fraud, there is a tribunal. It's a accident case, isn't it?
Yes, my lord.
Why do you go to the tribunal, consumer court?
No, no, this.
How can you go to the civil court? Tribunal is meant specially for MSCT, motor accidents. We have not understood why is the requirement of the succession? And why has this situation arisen?
My lord, under the master claim policy, my lord.
Everywhere there is a master policy, act policy, master different kinds of policies.
My lord.
for adjudication of a dispute, of the amount claimed, there has to be some,
Under the policy, if the insured dies, my lord, he is entitled to a lump sum, my lord, compensation.
it's not the insured. It's the vehicle which is been insured.
No, the person, my lord, he is also insured under the policy, my lord. That is what I understand, my lord. The policy is at page 16, I think. Personal accident coverage is also applicable, my lord. So the insurance did not dispute that, my lord,
It's a contract for indemnity.
my lord. The insurance only asked us that to process your claim, we need the succession
Who passed
certificate,
away? Sayador passed away.
my lord.
Your father passed away.
No, the son passed away.
Son passed away.
Son passed.
What was the accident? Let us see.
Death certificate annexer 2, my lord. The police report is 18.
No, where is the report, police report or police FIR?
My lord, page 18,
1/8.
1/8, annexer 3, type copy. 19 is the original.
To report. I'll just put it.
Now to look at page 39, annexer 10. The letter by the Orient Insurance Company, my lord. Says that to consider this case, you have to produce a will, probate, or letter of administration or succession certificate. Within 15 days, they say, my lord, on 25th January 2022. And we could get the succession certificate from the court only.
No, that part we do not have any difficulty.
My lord. The company raises any dispute as to my claim, of course, I have to go to some other court because the Reed court cannot entertain that.
No, but we are not, we have not followed the procedure. Now, this company, Oriental, is the insurer of the scooty in question. You said that the scooty was involved in an accident with a truck. Offending vehicle was a truck. Now, who will identify? Against whom will you make the claim?
My personal accident policy would cover that. Other claims might be probably made against the truck, my lord, the offending vehicle.
No, you're not entitled to have two benefits of the same accident. Either the truck pays or this thing. Insurance and that to matter accident is not a matter of a windfall, only just compensation.
My lord.
There is no determination of dependency factor, nothing. Who will determine? What was the age of the deceased? All these factors are not required to be determined.
27.
We'll have the views of the Oriental. I don't know how we have proceeded. We have serious doubts. The projection which you have made for that, there is no problem.
My lord.
They are asking for a succession certificate. 4 months have gone. That part is not a difficulty for us.
My lord.
But we are on the basics.
My lord.
Ahad, the B Pathak, counsel for the petitioner who is aggrieved by
closure by the action of the respondent company, Dash Oriented Insurance Company Limited, in closing the claim by the letter dated 19/4/2022, full stop. It is the case of the petitioner that his son, what is his name, Mispa, what is his name? Alfred
Mispa.
Alfred Mispa had passed away in a motor accident on 31/1/2021 while he was riding his scooty and was hit by a truck near 6 Mile, Guwahati. Full stop. The petitioner claims that there was a master policy in respect of which the respondent company had asked for a succession certificate which could be obtained from the competent court. And in the said process, some time was consumed. Full stop. However, in the meantime, by the impugned communication dated 19/4/2022, the claim was closed. Full stop. Issue notice returnable by 4 weeks. That notice be issued by registered post to TD by tomorrow.
Like I see that actually not the vehicle, the person concerned himself was injured. It's a different kind of a policy.
That is, it's a life insurance that means.
It's a life insurance with accident cover, basically accident cover policy. So not the vehicle, the individual is my lord. Annexer 1.
Let us have the views of
My
the
lord.
answer.
Of course, there is view.
Yes, next.
Safely.
But in this case, I have a limited prayer, my lord. My premises has been, my lord, illegally occupied, and my lord, a wine alcohol bar is now running on without having a proper license, and must, my lord, KMC has also not, my lord, act upon about my representation, that is page 39.
You're the owner of the premise.
Hello.
You had given it for rent.
Yes, ma'am. That has been expired long back, and thereafter, my lord, we have requested him to vacate. That has not been vacated. Now, in absence of the settled position, my lord, in absence of tenancy agreement, in my view, my lord.
Prithvi Center,
Pardon?
Ulubari.
Yes. My lord, page 39 and 40, my lord, only representation may be, my lord, considered by the appropriate authority in accordance with law within a specific time. That is my plea. Page 39, 40.
Yes, what do you say?
Basically,
In absence of a tenancy agreement, can the license be?
it can be renewed. Initial for grant.
It can be.
Yes, ma'am. The landlord has come without making tenant a party, making prayer against the tenant firstly. Secondly, that's a civil dispute.
But tenant is not a party.
Tenant is not a party. And he's making prayers, my lord, to the state, which will affect the tenant, my lord. Basically, it's a civil suit, my lord. He should have filed a suit for.
At least you need to.
I make it clear, my lord, we have also filed a civil suit for ejectment. There is no, my lord.
No, that's a different matter.
Yes.
But here you have to give
my
the.
limited page, that one, I have submitted representation. And that representation.
In
they have
fact,
to
my
act-
instruction is that, my lord, license has already been renewed. There was a order from the government, my lord, that now onwards, my lord, for renewal, annual rent agreement is not required.
But my lord, then this.
For the first grant of first license, rent agreement is required.
That means the department is not too much concerned with any dispute between. the-
Exactly, my lord. What our experience is, my lord, that every time, my lord, in the name of granting renewal, my lord, licenses are being harassed by the landlords, my lord. So to do ease of business, my lord, we have passed an order.
If that is the policy, Mr. Chamaria.
Then my lord, that another page there about trade license, that may be act upon, that respondents, 4 may be, 3 and 4 may be directed.
But at least you make the tenant a party.
But so far this lordship is quite right. My question that my lord, my only that if suppose they will act upon, my lord, then they will my lord, do the needful, my lord.
If they act, then it will affect the tenant. Isn't he or she a
They
necessary
will approach
party?
to the tenant, my lord, asking the necessary document, whatever required under law, my lord. And my prayer only to that extent, my lord, that my representation has to be considered, my lord. Whatever decision they would like to adopt, my lord, I have nothing to say. So far, first part is concerned, that will go, my lord.
You make the tenant a party.
My lord.
3, as summary learned counsel for the petitioner waives leave to add parties in this writ petition. At the outset, Sri Ian Goswami, learned Standing Council, Excise Department submits that the writ petition has been filed against the extension of liquor license, is it liquor license, bar license in respect of the tenant without making the tenant a party. Chamaria pays for and is granted leave to make the tenant a party respondent, for which a week's time is granted.
That's the only prayer, my lord. So far, this policy, may I get the copy, my lord, from my landed?
Definitely,
It will.
Sri Goswami has, the Learned Standing Council has also handed over a copy of the present policy of the Excise Department, as per which there is no requirement for the licensee to produce the renewed tenancy agreement for extension of the license.
So, my lord, it's not a, my lord, any circular, my lord, just.
Association requested the government has decided they will not insist. Apply.
Huh? 1 week. This after a week.
My dear lordship, madam. One of the petitioners are franchises, madam, under section 5, the electricity.
Franchisee of
Franchise of APDCL.
APDCL, okay.
APDCL, madam. Whole question, madam, we are continuing. From the petition number 1 went to the office and he came across with a letter, which is your lordship page by the 36. From that letter, we came to know that they are going to terminate. But till today, we have not got any notice, my lord. Page 36, your lordship.
Yes, Mr.
My lord, I have received instruction. My lord, may kindly peruse page 36 and 37 for a moment, madam. Instruction here.
Does the correspondence
By
between
this, by this communication, my lord, the concerned chief executive officers were directed. That includes, my lord, 2 of franchises of Karimganj, my lord, Badarpur Circle at page 37. Petitioners are also from Badarpur, Karimganj.
Yes.
There is no such decision to terminate their franchisee, my lord.
If this is not there, but your lordship condition.
As of today, my lord, there is no decision to terminate the franchisee of the petitioner. There is written.
Sri H.R. Chaudhary, Learned Counsel for the petitioners who are franchises under the APDCL. APDCL. The grievance is based on an apprehension that their franchisee may be terminated.
With effect from 1st May. This is there.
With effect from 1st of May 2023. Full stop. The on the other hand, Sri P.N. Goswami, Learned Standing Council, IPDCL has submitted that as per instructions received, there is no such decision to terminate the franchisee of the petitioner, full stop. He has further drawn the attention of this court to the communication dated 30/3/2023, which though relates to termination of certain franchisee, those are not connected with the petitioners. Full stop. Para. This court is of the opinion that there is no existing cause of action as on date, and accordingly, the writ petition stands closed. You tell me.
A copy. Obliged.
My lord, the petitioner before lordship are the landholder of under South bank of the river Berengi, my lord. The matter, my lord, relates for impugn mining operation, which has not been carried out in compliance of the environment clearance letter, that is 11/3/2022. It is page, my lord, 15. Here, my lord, some condition stipulated, and so far, my lord, condition number 26, I relied the measure for prevention of control of soil erosion and management. And the petitioner, my lord.
Now, you say that the lease has been granted without taking into account the environmental impact.
Lordship. And lordship, the petitioner are apprehending for likely to possibilities of erosion.
What has happened is I just got instructions from the DFO. The representation was filed before the DC. Before filing of this petition, we did not know that there was such a complaint. Now, if a petitioner approaches us with all the particulars, we'll cause an inquiry and look into the matter.
Conduct an inquiry, my lord.
But environmental clearance certificate has to be obtained by the lessee.
And your coordinates are there, your lordship. We cannot mine
And
outside.
only thereafter you give handover position, isn't it?
Yes, your lordship. Because before this petition was filed, we did not know that there was such a problem.
We issue a short notice
Very
then.
well.
Or P.K. Bhuyan, Learned Counsel for the petitioners are aggrieved by the grant of environment clearance letter to the respondent number 3 on 11/3/2022. Grant to the respondent 739. Full stop. The petitioners claim that such communication has been done without taking into account the actual facts and circumstances and is against the interest of public service, against the interest of public. Full stop. The petitioners also claim to have filed a representation dated 9/11/2022, which is yet to be considered. Full stop para. On the other hand, the KP Pathak, Learned Standing Counsel, Forest Department submits that the representation dated 9/11/2022 has admittedly been submitted before the Deputy Commissioner Barpeta, who is not the competent authority. Put the para, read it as it, comma. That notice of motion be issued. The Pathak, the Learned Standing Counsel, Forest Department accepts notice on behalf of respondent numbers
1 and 4. Your lordship.
1 and 4. M. Vermont Learned State Council accepts notice on behalf of respondent numbers 2, 5 and 6. That extra copies of the writ petition be served upon the Learned Counsel for the respondents by tomorrow. That step has been taken for service of notice upon the respondent number 7 by registered post which AD. Steps by tomorrow.
Respond number 3, perhaps CGC can approve.
Hmm?
Respond number
3.
Member secretary.
Member secretary.
3 member secretary is state level.
But it is represented by a central government office.
State level. I think 3, can you appear, Mr. Gupta?
State level.
Environmental Impact Assessment Authority. I think state.
But it's where it's done at the central level. The name is state level, but
Understood, but to who you can take
then notice.
3 and Harris, 3 and 7, 3 and 7 by registered post which AD.
I love them.
4 weeks. At 2 o'clock.
Mention to Your Lordship, I beg to mention item number 77 for adjournment. I've consulted the other side for adjournment.
This is not the time to, you had mentioned in the morning, I think.
You told me to consult the other side.
You are for whom? The petitioner. It is submitted that Sri J. Sharma, Senate Counsel for the petitioner, is unwell.
He's
He's
completely
unwell.
unwell.
Para, please, Dr. 2 weeks. 77.
Please, there in Malat 198 petitioners Malat, all are the job card are under MGNREGA Act Malat. And last financial years Malat, no job provided to the Malat petitioners Malat. And though Malat 24 schemes already sanctioned.
100 days is the guarantee.
My lord.
Yes.
I'll need to obtain.
Heard. Sri K.R. Padgiri, Learned Counsel for the petitioners. Full stop. The petitioners who are 198 in numbers are aggrieved by the fact that though they are job card holders under the NREGA scheme, no work was allotted to them in the last financial year. Full stop. Issue notice, returnable by 4 weeks. Union of India, Sri Nidhi, learned CGC accepts notice on behalf of respondent number one. Sri Devnath.
For 2, 3, 5, 6 and 7.
Learned Standing Council, PNRD Department accepts notice on behalf of respondent numbers 2, 3,
5, 6 and 7.
5, 6 and 7, whereas MS M. Bormon, Learned State Council accepts notice on behalf of respondent number 4. Full stop. There are extra copies of the writ petition be served on the Learned Council for the respondents by tomorrow.
Tendency shall not
By
be
by 2 days.
tendency shall not be about to provide the Malat.
That need not be
Otherwise-
said.
Obliging.
Arbitration.
Yes, my lord. In this case, my lord, he is correct, my lord. This clause is available, my lord. I have gone through the contract agreement. So I may be allowed to withdraw this petition with liberty to file, my lord. That was for the civil court, my lord.
Heard Sri NNB Chaudhary, Learned Counsel for the petitioner. Also heard Sri K.S. Barua, Learned CGC, appearing on behalf of the railways. Full stop. On the last occasion, Sri Barua, the Learned CGC, had submitted that the present dispute may not be one which can be redressed by arbitration as per the agreement in question, only claims which is less than 10%, 20% of the value of the contract can be redressed by the said mechanism. Full stop. Sri Chaudhary, the Learned Counsel for the petitioner, submits that after going through the provision in the contract, he endorses the submission made on behalf of the Sri Chaudhary submits that he has gone through the provisions of the contract. Full stop. While endorsing the submission, he has fairly endorsed the submission of Sri Barua, the Learned CGC, and waives leave of this court to withdraw this petition with a liberty to approach the appropriate forum for redressal of his grievance. Full stop. After hearing the parties, this instant petition stands closed with liberty as prayed for.
Please, your lordship. Last occasion, my lord, is supposed to produce the instruction.
Yes, yes.
Lordship, as per my instruction, his tender was rejected letter on Lordship because he does not have the required experience in manning a amending the central AC plan. It was erroneously accepted, his tender earlier. Later on, it was an inquiry.
Who is
was-
presently running
Presently, Lordship, the office is running the,
the plan? So we can examine this matter.
yes, Lordship. In the meantime, we will file affidavit.
It was erroneously accepted at
Yes,
the.
Lordship.
So here, one thing, my lord, they have earlier, they have issued a tender, my lord, that tender has been changed, my lord, date has been changed, my lord, by Terry. Corrigendum dated 21/4/2023, new tender has been issued, my lord. That is the date of last date is 6/5/2023, my lord. Continue.
Heard Sri D. Barua, learned counsel for the petitioner, who is aggrieved by the action of the respondent authorities in cancelling his selection as successful bidder pursuant to an NIT dated 25/2/2023 for the work of manning, MANNING, and operation of central AC plant for Akash missile at the Air Force Station at Jorhat, full stop, para. MS Devi, R. Devi, done at CGC, however, submits that the declaration of the petitioner as the successful bidder was by inadvertence, and on detecting that he did not fulfill the required criteria, his selection was cancelled. Full stop. Ms. Devi, the learned CGC further submits that at present the AC plant is being maintained by the office itself internally. Full stop, para. Issue notice of motion. Returnable by 4 weeks. MSRDB, the learned CGC, accepts notice on
All the respondents.
behalf of respondent, all the
All the
respondents,
respondents.
all the respondents, let extra copies of the writ petition be served upon her by tomorrow. Full
So
stop.
already I have served the
Extra copy served.
2 copies, sir.
Okay, last one, all right. It is submitted by Sri Barua, Senate Counsel for the petitioner, that extra copies have already been served. Full stop, para. Sri Barua, the Senate Counsel submits that as per information, our new NIT is being issued, full stop, para. In view of that, it is provided that any action taken for the work in question shall be subject to the outcome of this petition.
Obliged.
Please, Your Lordship. In this case, on the last petition, I was instructed to obtain necessary
Correct,
instruction.
correct. You have got the information.
Yes, Lordship. Some extent I have received the instruction.
What is it? You are agreed by the cancellation, isn't it?
Yes, cancellation or non-payment of bid, running bid.
The fact is that, Lordship, before this, the projection of the petition was that initially it was a proprietorship firm and subsequently the partnership firm, subsequently it was converted to proprietorship. And
Because I think one person had passed away.
exactly. one
yes.
person-
Father had passed away, I think.
Yes.
Did we remember?
It was not properly communicated, but the fact is that, Lordship, before cancellation, the review meeting, the cancellation of the review meeting was held. And accordingly, the petitioner number 2 duly participated in the meeting. And he was informed with regard to the completion of the construction within the stipulated period. And thereafter, the Lordship, this process was initiated. So there is nothing like that, he has not been properly communicated. And he has no information with regard to that. I mean, in the petition
But
also,
on that ground of cancelling,
yes.
that there is a change of the entity who was allotted the contract. Will that be proper? Is the change done to cause some inconvenience or legal prejudice to you? That is not the fact.
No, Lordship, if I place this particular communication, in that particular communication, there's a, before this cancellation.
Now, what is the reason? Tell us. Only because of the change in the status
No,
of the.
Lordship, because they could not complete the construction within the stipulated period of time. Lordship can.
Oh, this is not the reason.
No, Lordship, kindly have a look of this.
Oh,
particular
because
letter.
of delay.
Yes, Lordship, this is only because of the delay. The projection was on a different footing, Lordship.
Did you give notice?
Lordship,
Did you give notice?
the communication was there, Lordship.
Before cancellation?
Yes, Lordship, I have all the information, and this is the review meeting and the petitioner number 2 duly participated in the meeting. Can I place this particular letter, Lord?
We'll examine.
Yes, Lord. I'll find my retail affidavit
You
incorporating.
file
all-
your affidavit.
Yes.
Shri A. Ahmed Leonard Council for the petitioner, who has put to challenge an order of cancellation dated 23/9/2022, by which the contract which was earlier allotted has been cancelled. It is the case of the petitioner, who is the proprietor. Petitioner, which is a proprietorship firm, that when the contract was allotted, the firm was a partnership firm constituted between two persons. However, during the pendency of the contract, two persons, he said, father, son, the father had passed away, and therefore the firm had to be reconstituted as the sole proprietorship firm. Full stop. It is the petitioner has projected that only because of the same, the impugned action of cancellation has been done. Full stop. But on the other, this court, while taking up this matter on 21/4/2023, had directed the SP Chaudhary, Leonard CGC, to obtain instructions. Full stop. Sri Chaudhary, the Leonard CGC, has however submitted that as per instructions received, the cancellation is on account of the delay in completion of the work. Full stop. He has also referred to
21 of this.
a minutes of meeting, which was attended to by
Number 2.
the petitioner number 2, who is presently the proprietor, and therefore the question of not being aware of the background cannot be accepted. Full stop. Issue notice of motion returnable by 4 weeks. Sri SP Chaudhary, the Leonard CGC, accepts notice on behalf of all the respondents. Full stop. Let extra copies of the writ petition be served upon him by tomorrow. Full stop.
Interim period running bill has not been paid till date. Not a single.
I think there will be clause of forfeiture or something, risk and cost.
Yes,
Yes,
it is there, Lord.
But
You
there,
file your affidavit.
Affidavit.
That's what, Sri Ahmed, the Leonard Council for the petitioner, prays for an interim order for release of the running bills, or release of the pending bills.
pending bill.
Full stop. The same, Sri Chaudhary, the Leonard CGC, however, submits that since the work has been offloaded due to default on the part of the contractor, the entitlement of the parties would be determined, and only thereafter any amount which is entitled to by the petitioner would be released. Full stop. This irrespective of the matter is required to be stated in details in the affidavit proposed to be filed. 7-0. Yes.
May I please, Manoj? Manoj, that election to the Assam Pharmacy Council.
Yes.
I've got the instructions.
Hmm.
Regarding that, my lord, 1190, who are the, my lord, admittedly fake pharmacists. But the process was underway, my lord, in the meantime, because of the election. They could not be, my lord, their registration could not be cancelled, but they will not be entitled, my lord, for this
Voting.
election. Yes, voting for they want
Voting.
to. That may be recorded. I have got
Actually, you
that.
can have.
There is another point, madam. The most vital is that fine, they have done it. They have done it yesterday, madam. Till yesterday, it was not done. Done it yesterday, I am happy, madam. But the main point is, my lord, rule 8.2. Rule 8.2, madam. My lord will come to page 23. My lord, I've quoted the rules.
What is it? Tell us.
My lord, the rule says the manner in which the election is to be held. It says that a registered envelope has to be sent to each of the voters. And therein, my lord, inside there will be another envelope addressed to the returning officer with a form.
wherein, my lord, the particulars of the member has to be written and a separate form. Names of the candidates can be.
You said the links have not been given to all.
My lord, the process is registered post.
No, no.
But-
You said that they have opted for online, number one.
One,
Which
which
is
is in
not
violation.
prescribed by the rule. And number two, even in the online.
They have not
given the,
Not got it. So, my lord,
Is there, otherwise. But
but
everything is
without,
there
if
in
they have
the,
amended the rules, my lord, I don't have any case, my lord. But the rules is
But-
under the Pharmacy Act, my lord, 1946, Rule 40, Section 46.
so if we complete, my lord, may I submit, my lord, regarding this, my lord, procedure, admittedly, my lord, this time they have, my lord, adopted the online procedure, my lord, for voting.
but you ensure that all of them gets the pass.
Yes, but
My lord, the problem
statement
here is, there is no sanctity of that process, my lord. The server is with them. That data can be manipulated, my lord. Even the Election Commissioner of India till date, well, even for a small election is not, my lord, adopting the electronic, because it's not safe, my lord. Here we have a, my lord, proof as to the voting man, my lord. And it
My lord,
is
what
very
proof,
clear,
my
my
lord,
lord.
let him submit, my lord.
Everything is becoming
Yes, my
digital
lord,
nowadays.
Once the rule says, without what,
In the hot sun, you want to go to the office.
Lordship?
In this,
No. Nobody has to go. They'll send a registered post, my lord. All these are sent by registered post. And if a person does not receive, there is a provision made in the rule.
registered post, you have to go to the post office.
That,
or
my lord,
post box.
everybody in the near
My lord.
vicinity has it, my
You
lord.
do it from your home chamber
Yes,
My lord,
sir.
this is in violation of the rules.
under the AC.
How
My
they
lord,
have
how
previewed
can
this,
they-
my lord, let them show, my lord, how they will be.
When it's, you're
It's a
violating the.
different thing that tomorrow they have participated, they could not give their, my lord, cast their vote. In that case, my lord, they can come and say
Arre,
that
my
yes,
lord,
because of the online process.
If the rules are violated,
My lord, online-
what prejudice should I show, my lord?
Lordship will see, my lord,
My
the
lord, this, my lord will, because if 8-2, my lord, I have quoted it, my lord.
para
If
B.
they have violated it, fine.
Para B.
Yes, sir.
Para B, my lord, that-
Then, my lord, will see.
B is a problem.
No, see,
Shall be.
tell me, how can they do it, my lord? They know they can't do it,
Shall be
but still they are
amended
doing it, my lord.
appropriately to incorporate the so and so. for the
How can they
subsequent
incorporate it?
election.
For the subsequent elections, not these elections,
No, no, huh?
not these elections.
Not this election.
Ah,
So I leave it to your lordships, otherwise they can delay it, my lord, for some time, but otherwise the election will be.
No, I'm not on
No, no.
delay, I'm on a procedure.
Hold the elections as per procedure.
My lord.
Then amend the rules, come for digitalization.
Fine, do it. And then, my lord, there will be
Actually,
some.
you can have Senate Council, the Senate Council.
But my lord, one thing may lordship may give the liberty, that if they want to proceed as per the rules, that is by.
No, that
postal-
will allow you. You
Either
hold the
amend
election.
or this
Not
time. my lord-
liberty, we said hold the elections in accordance with law.
Yes.
Also, you can announce Senate Council. Assisted by Shri H.K. Das for the petitioners. Full stop. Also heard the big over Senate Standing Council, Health and Family Welfare Department. Full stop. Para, considering the subject matter of dispute and the instructions received by Sri Gogoi, the Learned Standing Council, pursuant to the order of this court.
I got the instruction from the Assam Pharmacy Council. They are the main concerned authority. And I'm appealing on behalf of them also. So this instruction has come from the.
And the instruction received by Sri Gogoi
Fine.
pursuant to the order dated 25/4/2023, comma, this writ petition is taken up for final disposal at the motion stage. Full stop. Para at the outset, comma, Sri Gogoi, the Learned Standing Council has clarified that the instructions have been received from the Assam Pharmacy Council,
Yes, ma'am.
correct?
Fine.
A copy of which is also placed before this court. Full stop. Para. The petition number 1 is the firm Assam raised. What is the Assam Registered
Registered
Pharmacist
Pharmacist Union, my lord.
Union, and the two other petitioners are its office bearers. Full stop. The grievance is with regard to a notification dated 10/2/2023 for holding the elections of 6 members of the Assam Pharmacy Council, which are scheduled on 27, 28, and 29th of April 2023. Full stop. The primary the challenge is a twofold one. And a challenge is made on two primary grounds. Full stop. Firstly, it is contended that there are
3,000.
around there were 3,000 numbers of
Fake pharmacy.
fake illegal pharmacists, of which a process was initiated for detection and cancellation, and in the meantime, 1810 such pharmacists, such fake license was already, such license was already cancelled. Full stop. It is the case of the petitioner that though the remaining 1190 was also detected to be fake, illegal, no final orders of cancellation were issued. And in that case, the elections are scheduled would be vitiated and would be reduced to a nullity as nullity, full stop, para. The second ground of challenge is that that as per section
Rule 8.2.
as per rule 3.2, I think.
8.8.2.
8.2.
My lord, I've quoted in page 23. my lord.
As per rule 8 within bracket 2 of the rules of 1959,
59. my lord.
Elections for the council are prescribed to be held in a particular mode by issuance of a voting paper in Form B. Full stop. However, the instant elections are contemplated to be held on an online basis, in which case, apart from the likely prejudice to be caused to the actual members, there the same is wholly against the rules. Full stop. Para. The senior council accordingly submits that appropriate orders may be passed to redress the grievance of the petitioners. Full stop. Para. Responding to the said submission, Shri Gogoi, the Learned Standing Council of the department has submitted that so far as the first ground of challenge is concerned, as per instructions received, the authorities have ensured that in the ensuing election process, the remaining 1190 candidates with fake illegal license would not be allowed to vote. He accordingly submits that since the substantial since the primary grievance of the petitioners have been substantially redressed, the elections may be allowed to be held. Full stop. As regards the second submission, second ground of challenge, submission, second ground of challenge, the Learned Standing Council has submitted that the decision to go for an online election system is as per the SOP formulated and communicated wide letter dated 18/2/2023. Full stop. He further submits that the rules of 1959 would be amended appropriately to incorporate the provision for online voting system for subsequent elections. Full stop para.
May I, in the point of rule 24, maybe, my lord, nothing has paid rule 24.
Yes.
Page, my lord, it's part 7 of the rule. General, it says, my lord, if any difficulty arises in holding an election, and in carrying out the provisions of these rules, it shall be lawful for the president to take such action or pass such orders as it may appear to him necessary or expedient. But my lord, if he exercises his right, my lord, he can't.
No,
vote.
that is not pertaining to the mode. You can postpone, you can do something else. He also will record that.
No.
The standing council has also drawn the attention of this court
From this one again.
to Rule 24, which gives some liberty to the president
And in
in
carrying
the
out
matter of holding election. Post of para. Heard and considered the rival submission made by the learned counsel for the parties. Full stop para. As regards the first submission, comma, as regards the first ground of challenge, comma, after comma, since it is the stand of the respondents that the remaining 1190 fake oblique illegal pharmacist will not be allowed to vote, comma, the grievance relating to that aspect appears to have been redressed, full stop. However, comma, so far as the mode of holding the elections is concerned, comma, the present method to go for online voting appears to be in violation, appears not to be in compliance, not to be in consonance with Rule 8(2) of the rules of 1959, which provides for which prescribes for a particular manner to hold the election. Full stop. This court is of the view that when there is a prescribed rule, comma, the same cannot be violated, and the method has to be followed. Full stop. The instructions, the part of the instructions that there is a contemplation to amend the rules of 1959 would be relevant only for subsequent elections, which can be held on an online system only after the amendment takes place and not before that. Full stop. In the celebrated case of King Emperor versus Nazir Hussain, reported in 1936 PC, AR 1936 PC 253. The law has been settled as follows. Full stop. Para. In view of the above, comma, this court is of the opinion that the writ petition deserves to be allowed by directing that while the elections which are contemplated to be held, while there will be no restriction, while there will be no bar for holding the elections in accordance with law, by ensuring that the voters are constituted only of the genuine license holder, comma, the mode has to be strictly in accordance with Rule 8 within bracket 2 of the rules of 1959 and the other statutory prescription. Full stop. Since the rule contemplates a particular method, comma, the elections which are likely to be postponed are, however, directed to be held expeditiously and preferably within a period of 45 days from today. Yes. This date posted now, I think 45 days. Representative stands disposed of.
Para, a copy of the written instructions dated 22/3/2023 is made part of the records. This we are retaining for.
My lord, only to one extent, subject my lord has covered it, but my lord, or page 44, that notification, only to the extent of that it prescribes using of the digital mode, that may require an interference. My lord. Otherwise, the notification is okay. Because of what my lord has said, only said which will be conducted using digital mode system, online voting system. To that extent, my lord may have to make an observation.
That is already covered. Lord.
Covered, but still, my lord, because otherwise.
Digital oblique online.
It says, my lord, here, 27, 28, 29 April from 7:30 to 5, which will be conducted using digital mode of system, online voting system. That word, my lord, only will clarify.
Digital voting oblique online system. Is it different?
No, my lord, that prescription in that.
No, is it different?
No, it's the same thing. I want only, my lord, that prescription in that notification to be interfered to that extent, my lord, if required, my lord.
Yes, next.
May it please the lord.
Yes, yes.
My lord, the petitioner before my lord is an aspiring candidate to participate in a tender process, my lord. In relation to my lord, supply of my lord Napier slips.
What is Napier slips?
Napier is kind of a fodder grass, which is grown in the wild mostly, my lord, and is used as a fodder for either for cattle or for those purposes, my lord. So, my lord, these Napier slips are to be supplied by the intending bidders, my lord, for which this NIT was floated. My lord, may kindly come to the NIT at page 74, it starts, my lord.
Agriculture department again.
Yes, same, my lord. In brief, before going to the terms, my lord, I would like to submit, my lord. The issue here is very simple, my lord. Originally, the NIT which was floated by them did not contain a condition which was prejudicial to any bidder or including the petitioner. And after announcing that NIT, my lord, few days after that, they came out with another corrigendum wherein they incorporated a new condition which now makes me ineligible. So I'm basically aggrieved by this particular.
What is the insertion? New?
Yes, my lord. This insertion, my lord, if remembers the same insertion of 4 crores.
Turnover.
Yes, my lord. 4 crore annual turnover they are seeking from me for supply of these Napier slips. And surprisingly, my lord, the value of these Napier slips, which is they are basically saying that we should supply. The value comes to, my lord, the total amount is, my lord, 3 crores 90 lakhs of Napier slips. So these are small slips, my lord, like in SMEs we call athi. In one slip, so they will have to supply around 3 crore 90 such slips, my lord. So now the value here in, my lord, is somewhat comes to, my lord, 9 crore 75 lakhs. Total value of this 3 crore 90 lakhs Napier slips comes to 9 crore 75 lakhs, which I have stated after calculating. Now they are seeking a security, financial security from us amounting to, my lord, 12 crores. 4 crore per year, average annual turnover. Meaning thereby, I will have to give consecutively for last 3 years a turnover of 4 crores, totaling to 12 crores. The value of the bid or the work in question is just 9 crores 75 lakhs, which, if Lordship says, is more than the value of the price of.
No, it is annual turnover, 4 crores. You cannot say 12 crores.
No, my lord. If had it been a case that only a turnover of one particular financial year they are seeking, then I would have understood that, yes, my lord.
No, last 3 years, you want to say, we are not on the whether it's justified or not.
Yes, my lord, of course.
But your interpretation may not be correct.
My lord.
Last 3 years, you want to see whether you are consistent or not. 3 years, you need to have a turnover of 4 crores. Doesn't mean that total turnover is 12 crores. That's not the thing. What is the turnover? What's the meaning of turnover?
Annual turnover per every financial year, my lord.
What is the meaning?
That in a year, your net profit.
Would it be cumulative? It's not cumulative.
No, absolutely.
It's every year calculation.
Yes, my lord.
So you need to be a consistent businessman having a turnover of 4 crores in the last 3 years.
Yes.
They want to see your background, but whether that's justified or 4 crores, that's a different matter.
Different.
It's not 12 crores.
So I'm on a very limited prayer, my lord, hearing, my lord. Today, I don't want the tender process to be stayed, or they should continue with the tender process. Only my humble submission is that, my lord, they may allow me to participate.
What was the initial condition?
There was no such condition, my lord. I'll come to that point.
Turnover was not there.
Nothing, my lord. Please, lordship may kindly come to page 109, my lord. 109.
This had come up or what?
My lord,
Coming for the first time.
this is come up for first time. Tomorrow is the last date of, my lord.
Why do you give underlined or
I'm
marked
sorry,
copy?
my lord, but I actually, my lord, while
It's not
filing,
the way.
I'm extremely sorry, my lord.
Court copies are to be marked only by the bench,
Yes, my lord.
not by counsel.
Yes, my lord.
You've given pencil marked copy.
Yes, my lord. I'm sorry, I forgot to, my lord, erase. My lord, I was in a hurry, actually, my lord. Sorry, my lord. Page
Pardon?
page 109, my lord. It starts 10 is the relevant part. These are the qualifications required. 110, my lord. Yes, my lord. Here are the qualifications to be eligible to participate from 111, 1 to 9.
Yes.
I'm otherwise eligible from 1 to 9. Now, corrigendum, if your lordship comes at page 168, my lord. This corrigendum was issued on 30th March 2023. If I may read, my lord.
Added.
Yes, my lord. At serial number 3.
Added.
Yes, my lord. Added. Bidders should have an annual average turnover of 4 crores in the last 3 financial years, that is 2019-20, 2021, and 21-22, my lord. So it is also a case, my lord, wherein, my lord, it is again difficult for these small and medium enterprises like the petitioners, my lord, to have a consecutive 3 years of turnover.
What is otherwise your turnover?
Around, my lord, as per my client, 1 crore to 1.5 crores, my lord, average annual turnover, my lord.
What is the value of the supply?
My lord,
What is the standard value of the supply?
standard value I have calculated, my lord, it will be amounting
9
to
crore.
9 crore 75 lakhs,
In the 3 years?
my lord.
In the 3 years?
No, my lord, the total quantum value of the entire work in question, my lord, that is a bid value, which I have stated in paragraph number 11, my lord, if my lord may come, kindly. At page 22.
And you have to complete the supply within how many days?
That is 3 days, my lord.
3 days.
3 days. In the NIT, they say, I'll come to that point, my lord. Yes, my lord. At page 79. So 3 days from the date of issuance of the supply order as per schedule to be provided by the director, the bidders will have to supply.
From where do you get this capital for 9 crores?
No. 9 crore is the value. I am the authorized supplier of my parent company. So my company, who has not participated in the bidding, may not participate in the bid, but they may have the finance to finance me to basically supply this, because I am a representative of my company, because in the NIT, if your lordship remembers, either the manufacturer, they can come directly, or the authorized representative can come. My lord, in that way.
You are an authorized representative.
Of my company, my lord, who basically deals.
What is in a company?
My lord, that, my lord, I cannot discuss, of course, my lord, because now the technical, I'm this supplier, my lord. So they have different companies, my lord, who basically deals.
Where have you stated?
My lord, at page number 1, my lord. First paragraph.
Not 1, 8 then.
Yes.
First paragraph.
Yes, my paragraph number and page number in.
Is number 9.
My lord. He is an authorized supplier contractor under the agriculture and entering Blemish service and path, previous purported department, petition is supply of Napier slips, my agriculture department, and also requisite eligibility criteria.
No, that we have understood. Even if you are a supplier, you have to buy from somewhere. And are you in a position to buy the quantity for 9 crores?
My lord, when the amount is, my lord, they have not given a basis. This is my rough calculation of 9 crore 75 lakhs, my lord. At page number, if your lordship comes. 22, my lord. every bidder who would be, my lord, bidding for this particular NIT, my lord, will have some financiers behind them, my lord, who would be financing either in a way of an authorized, my lord, either by his manufacturer or by the
Mr.
company.
Chaudhary, what do you say? Last case was similar.
My lord, only relating to the challenge that we have made. It was maize, if your lordship
No,
remember.
that we know.
Yes, my lord.
This product is different,
That is completely
but the grounds of challenge was the
different.
same.
Was same, my lord.
Lordship, here in the original NIT, Lordship, those
not there.
conditions were not there. Lordship, may kindly turn over to page 88, Lordship.
38,
88.
88. Yes,
Lordship, clause 8. It gives the power to modify the bidding
document.
conditions. Lordship.
No, even if you don't have an express power, you can bid, amend, but
And-
that needs to be reasonable.
Yes.
Only thing is this.
Lordship, because here there is no bid value, only the quantity has been specified of 3 varieties. And Lordship, it's the price the bidders will.
Can you just apprise this court? What is the objective of inserting a clause requiring 4 crores of annual turnover?
Lordship, mainly the sustainability, whether he can continuously, because it will be over, though he will have to supply within
It's a
3 days.
matter of 3 days. If he's not able to give, it's not a work contract, that he starts the contract, he takes months after months.
No,
3 days, if
Lordship,
he's not
because
able to
it's a
supply, then-
huge quantity and he will have to apply to all the districts of the state.
Understood.
And
It's only
Lordship,
a
just the sustainability of the project.
Only a 3-day thing. Okay, allow him to participate without,
Lordship, then in
Yes.
that case, Lordship, because it will be relaxing the eligibility condition.
no,
Lordship.
you don't.
And it will, and Lordship, may can you look at his prayer, Lordship. It will amount to the final relief, Lordship.
Not amounted to final relief. Tomorrow, if he is out in financial, then his entire case is gone.
Lordship,
No, no.
otherwise the farmers will get affected.
I'm not staying, my lord.
See,
Staying for same. my lord.
if he is out on the financial criteria, then the case ends there.
Financial criteria, Lordship, he has already quoted the price, Lordship, in this petition. He is making an assumption 2.75 rupees per slip, Lordship. That will be there, Lordship.
I may quote over and above, my lord. I'm not paying for staying this process, my lord.
Hard, the age Bura go hai.
Lordship, I would like to rely upon a decision, Lordship.
Learned concept.
Mainly following the Lordship Ronak International.
Will not have a blanket state. Which paragraph?
Lordship 9, 10 and 11.
Nine, 10 and 11.
That's all.
Learned counsel for the petitioner who has put to challenge the insertion of a condition of a tender condition with regard to an original NIT dated 27/3/2023. Full stop. The contract in question is with regard to supply of Napier slips and in the NIT dated 27/3/2023, 9 conditions were given as qualifying criteria. Full stop. The case projected by the petitioner is that it fulfilled all the 9 criteria and was eligible for participation in the same. Full stop. However, by the impugned corrigendum dated 30/3/2023, a new criterion has been introduced with regard to annual turnover. Full stop. As per the new criteria, as per the said criterion, a bidder is required to have an average annual turnover of 4 crores in the preceding 3 years. Full stop. The case of the petitioner is that such insertion is absolutely unreasonable and arbitrary without having any nexus to the object to be fulfilled and has been introduced only to limit competition. Full stop. Para. On the other hand, Shri B. Chaudhary, Standing Council of the Agriculture Department, has submitted that the contract document itself empowers the authority to amend the bidding documents. And in this connection, he has referred to clause 8.1, clause 8 of the same. Full stop. He further submits that the requirement is not irrelevant, and in support of his submission, he has placed reliance upon a decision of the Honorable Supreme Court in the case of Rajasthan State Warehousing Corporation versus so-and-so, dated 24 June 2020. Asked in civil appeal number. Issue notice returnable by on Shri Chaudhary, the Standing Council Agriculture Department submits that accept notice on behalf of all the respondents.
Yes, my lord.
All the respondents. That extra copies of the writ petition be served upon him by tomorrow. Full stop. Para. Heard the learned counsel on the interim order. Full stop. On the interim prayer. Full stop. Para. The learned counsel for the petitioner has submitted that if in the meantime, the tender process is allowed to be gone ahead and finalized, there the entire writ petition would become infructuous. And he further submits that a prima facie case is made out
made out, full stop. It is also the submission of Sri Buragohai that in a similar matter pertaining to supply of hybrid maize, an interim order was recently passed by this court in WPC number
760 of 2023, my lord,
760 of 2023.
dated 10/02/2023.
10/02/2023. Para. After hearing the parties, though this court is not inclined to pass a blanket order of stay, it is directed that without rehearse the fact that the petitioner has not fulfilled the requirement of the new criterion inserted wide the amendment dated
30 March.
2023, the petitioner would be allowed to submit his bid, which may also be opened along with other qualified bidder. Full stop. However, no final orders of allotment be issued till the next date fixed. Full stop. Para. Since the matter pertains to supply of goods which is of public importance, that the instructions be produced on the next date, which is fixed on.
Any date convenient for my lord.
Tell us.
Lordship, next week.
Today is 26th.
Yes, ma'am.
Can we have it on 4th?
Yes, ma'am.
Thursday we'll have it
My lord.
on 4th. Last minute. It is, if in the meantime, the financial bids of the parties are open, the same may be produced before this court in a seal cover.
I'm deeply obliged, my lord. Deeply.
Mr. Deco, Mr. Sawala, what is this?
Well, this is the matter relating to a notice being issued by Surapata Municipal Board, my lord. What has happened, my lord? I am a patadar of a land measuring 2 kata. I parceled in 21, applied.
Registered still did.
Yes. And then I got a permission. According to the permission, my lord, I started construction. 6 months have lapsed after construction, my lord. All of a sudden on 13/3/23, they issue my notice that under special instructions, please do not further continue with the construction.
MLAs.
So now what happened? We again filed 2 representations. They
How
did
did you
not-
know it was the MLA?
We visited the office, Your Honor. As per the instructions, in the instruction notice itself, they said, you please come and visit the municipal office. So
This is your personal knowledge or is there any document?
There's no document.
You're sure it's the MLA,
Absolutely.
not his family member?
I don't think so. Maybe. Well, that may. So,
Maybe his wife or son or somebody.
maybe, my lord, but something like that, my lord.
Which place?
Surapata, my lord.
Purupothar. Yes. Madam.
The board will answer. Well, I can only accept notice on behalf of.
Yeah, we'll definitely issue notice, but interim order will be difficult for us.
My lord, only thing is that, my lord, we may be allowed to continue as per the permission granted.
We'll have the instructions. See, interim orders have to balance the equities. You make it a plan for the case, but balance of equity, you are not going to suffer irreparable loss by two weeks. You have the instruction. If your environment is correct, then we dispose of
But
them.
otherwise also, my lord, one person comes up without a show cause, says that you stop the construction. If you see, my lord.
No, that is your projection. We do not know, we haven't heard the other side.
My lord, that is correct, but the notice itself says that you stop construction. We have got some special instruction. What are the special instructions?
Let us have the instruction.
The only thing is that, my lord, if you see
We,
the,
we can grant you the final relief, that this is not a case for interim relief.
my lord, but
If you grant the interim relief, what is there to be decided? Tell us.
my
Without
lord,
instructions.
no, we have already got a
We
very,
can stay something. We can, but this is giving a positive mandatory in the injunction without hearing the other side.
I'll leave it to the wisdom of the court.
No, just 2 weeks. And it's going to, heaven is not going to fall. Madam, get the instructions.
I will.
My
If the
lord,
projection made by the petitioner is correct, then there is no question of any further instruction. We'll allow the repetition. But if there is something else, we do not know.
My lord.
otherwise also, my lord, once permission has been granted, if you see page 35, the
Good,
photograph.
Heard Sri A.K. Sayola, learned counsel for the petitioner. The petitioner claims to have purchased a plot of land at Hurupothar,
Municipal board, my lord.
at Hurupothar.
At Horupot.
Sorry,
In the
Golaghat
district.
district,
Huh?
Golaghat district.
That, no, it's not Hurupothar.
Horupot.
In Hurupothar, in the district of Golaghat, by registered sale deed, whereafter he, lady, huh? Petitioner is a lady,
Lady, my lord.
whereafter she had started construction of an RCC structure by taking permission from the Hurupothar Municipal Board. Full stop. However, when the construction was going on, a notice dated 13/3/2023 has been issued by the respondents to stop construction without assigning any reasons. Full stop. The petitioner has projected that when the office of the respondent was visited, he has been made to understand that there has been some special instruction of the local MLA.
Local
As a
MLA,
result
my
of
lord.
which, local MLA, as a result of which the construction has been directed to be stopped. Full stop. Tara. If the projection made by the petitioner is correct, a case for interference is made out. Full stop. However, it is required to have the Learned State Council get the instructions on the projection made by the petitioner. Para. Issue notice returnable on 8th of, not 8th.
My lord, custody service can be done and if the matter can be taken up a bit earlier.
Where's the 8th? 8th is not too much. Just,
Fourth, my lord,
huh?
fourth,
Today is what?
today is 26th.
4th.
Huh?
Will you be able?
I'll,
You'll not be able to take instruction. I have it on 8th. We grant you dusty also. On 8th of May.
my lord, then some other day, after 10th, 11th, 12th, something.
On 12th or 15th.
12th.
On 12th of May. MS S. Sharma, Learned State Council accepts notice on behalf of respondent number 1.
One only.
1.
My lord.
Municipal Board.
2, 3, 4. My lord, will give custody.
Okay, 1. Let an extra copy of the petition be served upon her. Full stop. Sarah, that be taken for service of notice upon the respondent numbers 2, 3, and 4. I registered post PTAD. Full stop. The Learned Council also craves leave to serve by dusty. Full stop. Such liberty is granted. Full stop. However, the justice service is required to be routed through the registry of this court and in the notice accompanying the dusty, the next date is required to be given. Full stop. The petitioner is also required to file an affidavit on before the next date, which as a proof of the justice service. At least on क्या बोलूं?
12th, my lord.
12th.
Okay.
Yeah, please, your lordship. Hello, this is an application for implement as a party respondent in the Malad file by the railway. Your lordship is
It
aware.
is by the railways.
My lord, two writ petition has been filed. One is by the private parties and another is filed by the railway.
You are Jagannath Kumar.
Yes, my lord.
You want yourself to be implemented
Yes, in the
as what? As a respondent number?
respondent number 4, my lord.
Or who is for the petitioner? Opposite party. Who had appeared earlier? Edas Gupta.
Yes, my lord, and
Are they aware? Railway is aware.
aware, my lord.
Anyone appearing CGC? You are with whom?
Lordship, I'm for Mrs. Egan, on behalf of Mrs. Egan.
Till she can appear for the railways.
Yes, sir.
Is she around?
Yes, sir.
Call her.
Yes, yeah.
Hmm?
She's in another court, Lordship.
Okay. Then we'll do one thing. We'll allow this. What is your interest?
My lord, in the writ petition, my lord, filed by the private parties, my lord. I have been made as a party respondent, my lord, and in that writ petition, my lord, the revenue department has filed an affidavit, my lord, taking care of my claim, saying that yes, this is his lane, that is the lane of the applicant. And in the writ
Madam
petition,
Gayan, it's a railway case. But earlier, he has filed this application for his implement as party respondent, but in the writ petition filed with the railways, Mr. Dasgupta is appearing. Along with, I don't know whom. Who's there with him?
Kumar Chakrabarti.
Chakraborty, yes. So, will you appear or will you,
No, my lord, in this case, Das Gupta, sir, and I may be allowed to call him.
for the timing, you take notice, or implement, it should be done in his presence. I think,
Notice
in
will
fact,
be issued, my.
no, not issuing notice, implement application. We'll allow this, try to call him or Mr.
May I try
Chakraborty.
to call him?
Him or Chakraborty.
Yes, sir.
Mr. Chakraborty,
My lord, in this case, our name has not been shown, my lord.
SC Railway is soon.
Yes, but otherwise, my lord, in 188, I was.
That is why we have called you.
My lord, we'll file an objection to this implement.
Implement.
My lord, we have to file an objection because our reputation is,
You don't think about your fraternity.
my lord,
Think you
after
should
all,
be
my lord, I am
considerate.
representing a department.
You
It
should
is
be
the-
considered somebody has got a brief and you're trying to
My lord,
deprive him.
no, he's all along appearing in this matter, my lord. It is not the first time.
Other also he'll appear.
My lord. So at least I would like to put on record.
Or
an
you are
objection.
thinking about your interest. That is also
My lord,
important.
yes, that is also important. My lord. Interest of self-interest as well as the interest of the
Then we'll
department.
balance the interest.
So we need.
We'll allow him, but not today.
But-
And you will allow him to allow you to file your objection. Heard. Three case in a Learned Council for the applicant who by means of this application seeks implement as party respondent number
4, my lord.
4 in the connected, not connected, in WPC 1838/2022, full stop. It is the case of the applicant that he is a necessary party and any decision taken in the writ petition may adversely affect his interest. Full stop. Para. On the other hand, comma, 3, Chakraborty, S. Chakraborty, Learned Council, Standing Council Railways,
No, my lord.
Learned Council
Railway-
appearing for the railways submits that there is no basis of implementing the applicant and he would like to file an objection. Full stop. Para. In view of the same, comma, let this application be listed after 3 weeks, by which time objection, comma, if any, may be filed by the railways.
May I pray for a date, my lord?
List on
15th,
May 15th, 2023. registry to reflect the name of Sri S. Chakraborty and Sri A. Dasgupta in the Cosby. A. Dasgupta Senior Counsel for the railways in the Cosby. For the railways. Yes, next.
Wait, please, Your Lordship. Lordship, instruction is awaited, Lord.
May I lost, draw your losses of attention to order dated 5/2/2021. So by this order, my lord, the 3 weeks time was given to the Learned Council for the representing the Karbi Anglong Autonomous Council, my lord. So outstanding dues, my lord, long, my lord, spanning from long time, my lord. Now I am suffering, that is why, my lord, there is urgency in the admitted amount, my lord.
Yes, madam, you're granted time.
Keep on taking time, my lord.
Lordship, this is the second time.
Don't have got a bit. But you have been paid.
No, my lord.
Some
There's a
amount has
part,
already
part
been
of
paid,
the
Lordship.
amount is.
How much is the amount you are
Now,
claiming?
my lord, it is, my lord, as per that order, 36,089, 36,89,000 is pending, my lord. In fact, my lord, after filing.
How
of
much has
this-
been paid?
My lord,
How much has been paid till now?
my lord, initially it was 71 lakhs, and now, my lord, during the pendency of the case, my lord, immediately after filing of the case, 1,82,000 was paid.
Only 1 lakh.
Meaning there were 35,700.
It's still pending.
35 lakh 7,000 is.
We
pending,
thought the substantial amount was paid. Only 1 lakh paid.
my lord.
Madam,
Lordship, some time I'll obtain instruction.
you get this and ask your clients, advise your clients to make the payment if it is entitled.
So in fact, my lord.
Otherwise,
I oppose this honorable court by way of filing a contempt petition. There is a communication in the petition, my lord. It was sanctioned,
After
my
the-
lord. The
after
amount
the
of sanctioned,
lordship-
even after, my lord.
After that,
horrible
Lordship,
thing.
some amount has been paid already.
How much?
Earlier it was 71 lakhs, 33,200.
Now?
After that, we have, outstanding amount is now 36 lakhs 89,000, from which,
Oh,
as he has,
35, 50% has been paid.
yes, Lordship, and
No, therefore,
1 lakh again
oppose
it
this
has
honorable
been
court.
paid.
This amount is pending, my lord. So I am in a difficult position. That is why, my lord, some is indicated in the earlier order, my lord, in spite of.
Your Camprai,
Lordship,
S Camprai,
Lordship.
MSS Camprai, Learned Council appearing for the KAAC. Pays for more time to seek instructions for para. However, the Goswami, Learned Council for the petitioner submits that this matter is pending since the year 2020 for instructions, and a substantial amount is still due to be paid to the petitioner for para. In the interest of justice, a further opportunity is granted to the Learned Council for the KAAC to obtain instructions for para. It is made clear that this court would be reluctant to grant further time. Full stop. Let the case be listed on 17th of May.
Highly obliged, my lord.
Come with instruction.
Lordship, obliged, Lord.
I advise your clients.
Lordship.
Next.
That lead process.
Yes.
Well, it is that case
Yes,
where, my
yes.
lord, we apply.
Now
for
you have the
jurisdiction.
briefs.
Yes.
That day we did not have the briefs.
Today now. My lord, I have made a very small prayer today, my lord. But because of the fact that, my lord, there was an objection to our petition for mutation, saying that there was a decree of the court. We came to this court seeking for the case records and a copy of the decree and the order sheet to how there was a decree. And that was untraced, my lord, and as of date, my lord, there was not there. And later on, it was seen in the records also that particular objection which they had filed, stating about the decree and all has been removed and some other objection is there, my lord. So now perhaps if you proceed that there is no decree to the effect, my lord, then, my lord, perhaps, my lord, the direction may be given to the deputy commissioner, my lord, to make an inquiry as to my entitlement and pass an order for mutation, my lord.
Yes. Heard Sri G. Chaudhary, Returning Counsel for the petitioner. Also heard Sri P. Bharadwaj. Also heard MS and Baudelaire. Who was there? What parties? Also heard revenue, MSN Baudelaire, standing of the Revenue Department for responsible 1.
2 and 3, my lord.
No. 2 is not her.
Deputy
State Council, State Council. You're State Council. And CKS Burwal, State Council for responsible 2 and responsible 4 is represented from Mr. Chaudhary have come by Sri M.K. Chaudhary and Senior Council, assisted by Sri P. Bharadwaj. Full stop. Before going into the facts projected, Sri P. Chaudhary, Learned Counsel for the petitioner, has submitted that that in view of changed circumstances, he would restrict the relief rate to the effect that the Deputy Commissioner Kamrup may be directed to consider the case of the petitioner in accordance with law. Full stop. He has submitted that initially an objection was filed by the private respondents making reference of some court case and a decree, which however could not be traced out by the petitioner and therefore was expressed that he would suffer prejudice in defending his case. Full stop. However, he submits that subsequently the objection was amended and
Detailed objection was filed.
and subsequently our detailed objection has been filed, wherein there is no reference to any court case. Full stop. Full stop.
No, Mala is there.
No decree, he said no decree is there.
They got it.
So today, how do we say that without my lord filing their affidavit, my lord, in this case? Because kindly see the record which has come, that is the record, my lord, which has come before this court on the direction of this court. That record does not contain, my lord.
Where is the record?
What is?
Record very visible that, my lord, these are the documents, all documents. Was filed on 30th of October 2018.
The lordship kindly sees, my lord, page 119, my lord, of the writ petition.
This is the objection. They have given the my lord objection without trying the annexure. It's not their case, but there is only the objection. Not
Yes, it is my case, my lord. Specifically, I have stated.
Let him go to the deputy, ask for the documents, we will provide the.
And that is why we call for the deputy records for deputy commissioner. The records which has come, my lord, kindly see, my lord, that my lord records that objection at page 119 is not there. There is some other, that is what I have been all along, my lord, saying before this court, my lord.
What is your name? Maladatta?
Malad. এখন নাই পোৱা, এখন নাই পোৱা, এখন ইয়াতে দেখা পাইছো। কোনখন? কোনখন? 119 এখন পাইছো আমি, এখন পাই পেলাই আমি কোৰ্টৰ ৰেকৰ্ড বিচাৰিলো আপোনাক, ৰেকৰ্ড নাই, কোৰ্টত আহি তাৰপিছত কোৰ্টে যেতিয়া ৰেকৰ্ড কল কৰিলে, এইটো ৰেকৰ্ডতো বেলেগ অবজেকশ্যন ওলাইছে, এইখন অবজেকশ্যন নাই তাতে। Thirty 10 2000.
We have senior objection. There is no reference to any court case.
No, my lord, my learned friend, the records must be the objection of the private respondent hearing was filed before the circle office. That is
Yes.
on record.
Yes.
But we have filed, my lord, failed the objection, my lord, additional deputy commissioner when the there was about to the problem. And that has been, my lord, annexed in the repetition.
Yes.
That has been annexed, page 119, my lord.
Yes.
And your lordship will see.
What
this.
is the date of the this thing, the tick which you are holding?
30th of October 2008. Your lordship comes to page 109, is 30th of October 2000.
Now this, before the circle officer, it was 28 to 2018.
28 to 2000, right? And he, without getting this, my lord, how could he have annexed it? Page
This
109.
I have got. How, when did I say that I did not get this, my lord? What type of a submission is being made?
But
my
the
lord?
record,
But
record,
you have
What am I saying? Kindly understand. My lord,
make
kindly
submission to
understand.
the court.
Yes, yes, no, not to you, not to you. I don't hear you, Mr. Chaudhary. Don't show me that.
no, Mr. Chaudhary, this is not proper.
No, my lord,
No,
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 last
this is
page
not
also, my lord, no, my lord, I am trying to submit before this court, my
Don't
lord.
come before this court. Don't come to this court with this kind of argument,
No, my lord,
this kind of
kindly say,
behavior.
no, my lord, I am
We
trying
won't
to, I
tolerate.
am submitting before the court, my lord.
We won't tolerate. And maintain some decorum.
No, my lord, on the last occasion also, my lord,
Sorry.
he was told, no, my lord. He
Sorry.
will not come out.
Have some decorum.
My
Legal
lord,
counsel is
I am
there.
explaining to the court, my lord.
Yeah,
I
we
have
are
explained
here.
to him also, my lord.
We'll control the court.
I know, my lord, I
We'll
have
control
explained,
the
I
court.
have explained to
I'm
him
ready
also,
this
my lord.
court.
My lord, he is telling, my lord, how come I have
Don't
come
let
to
this
that,
senior
my lord.
counsel like
There
this.
are two records, my lord, before this court, my lord. One is there which I have
We
got
have
from them,
understood
my
your
lord. I have
case,
brought
Mr.
it to the
Chaudhary.
court, my lord.
You have understood your case. We have been maintaining decorum in this court.
My lord, I am maintaining my decorum on the last
Then
occasion
what
also
is
for
that?
that which first, my
Look at
lord.
him and
I
make a
was talking
success.
about the client, my lord. He put it upon himself, my lord.
Sorry,
Why should I say something to him, my lord?
please to refer any other court. Yes, next.
I am obliged, my lord.
Here also all of the outstanding bill for the petitioner. But the last occasion, the by the order dated 24/8/2022. The finance department is also included as a party.
Notice was issued. Any instructions?
Lordship,
Which department is this?
Lordship, PH department.
This, what is your instruction?
Lordship, they are claiming of an amount of rupees 37,70,279 rupees. But as per our department verification, we found payment copies of order amounting to rupees 20,31,817 rupees.
Okay, have you made any payments?
Not yet, Lordship. If to deposit the fund.
But you have to make the payments. At least admitted amount you pay, rest will decide.
Moreover, Lordship, have submitted the fund demand.
Yes.
Lordship, they are yet to receive without budgetary provision. Yet to receive the budget. That it
Well, that is why Malad earlier occasion you also either the finance department, depending on the finance department, accept the notice, Malad.
Finance Department is a party, yes, Mr. Talia. You get the instructions. Part 3, UK Goswami, Senate Council for the petitioner, who by means of this application is praying for a direction for release of contractual dues amounting to rupees 37,17,279. Plus this full stop. Sri Hassan, the learned counsel appearing for the Public Health Engineering Department, however, submits that as per instructions received, comma, the amount is around rupees 20 lakhs. Full stop.
20 lakhs, 31,000.
We approx 20 lakhs. Full stop. Para. So ye chaliya, learned counsel representing the finance department, however, submits that instructions are awaiting, and he prays for some time. Where are you? You're not, oh, okay, you have been implemented. Finance department respond number 6. That, last night. Prays for some time. Put the para, when can you come back? 2 weeks. List after 2 weeks. To enable Sri Chaliha to obtain the instructions. Okay, next. Date, yes, tell us.
17th of May.
17th of May. List of 17th of May. You'll get the instruction, yes. Yes, next.
For some more time.
What is this? Payment for?
Supply.
Oh, contractual.
Towards
Okay.
implementation of the scheme. Lots of open.
22 matter. Yes, get the instructions. Sri N.K. Devnath, Learned Standing Council of the department prays for and is granted further time of 3 weeks to obtain the instructions. It is however made clear that this court would be reluctant to grant further time to the department. Yes, 31.
The respondent filed affidavit of opposition today.
5. Who is 5?
Commissioner of.
It is state tax or what? State tax or central tax? Not aware. What of the brief?
State tax.
Who's there? State tax? Which Chaudhary? Taxation. You're with whom? B. Gogoi. Okay. Yes, what is your prayer?
One is 2 weeks.
File rejoinder. Affidavit filed when?
Today.
Today. Okay. This court has been apprised that the department has filed the affidavit of opposition today. Full stop. On the prayer made on behalf of the petitioner.
There is an interim order.
List after 3 weeks to enable filing of rejoinder affidavit. Full stop. Para. Interim order passed earlier to continue till the next date of listing.
Your Lordship.
Relating to non-payment of contractual.
File your affidavit in opposition, no. Why?
Instructions, Lordship.
Instructions received. With Sri Hassan, the learned counsel, PhD,
Yes, Lord.
learned counsel for the Public Health Engineering Department submits that instructions have been received, based upon which he would like to file an affidavit full stop. List after 3 weeks for the same purpose. Is there any interim order? No.
No.
Yes, next. 33.
Hello, the respondent number 4 affidavit, my lord, this covers the case of the petitioner to some extent, my lord. Only thing is that, my lord, the land of these petitioners, Assam Mala Road project. Affidavit paragraph 7 and 8 says that they are verifying the land of all the petitioners. On last week of March, my lord, they have also visited the land of this petitioner. So on that same scenario, my lord, my submission, if your lordship may dispose of, I am confined my submission to the relief that whatever may be the outcome, my lord, if they communicate to us whether our land has been included or not.
Affidavit has been filed when?
The respondent 4, my lord. Their paragraph 7 as they have said, my lord.
Paragraph?
7 and 8, my lord.
Hmm.
They stated that verification of the site is going on, my. What re-verification?
Sri B. Barua, learned counsel for the petitioner. You, Mr. Dutta, you have Sharma for?
Lordship, I am for
For? NCLs. Who has filed the affidavit? NCL?
NCL, my lord. Is the revenue authority.
Yoshi Sharma, isn't it?
Yes, sir.
Also Sri C. Sharma, learned counsel for the NCHAC, which has also filed an affidavit on 8/12/2022. Full stop. Madam, you are there? MS N. Bordoloi, understanding council revenue is present. Madam, you are also there. So is MS S. Sharma, Learned State Council, full stop para. Considering the end of the NCHAC in its affidavit, comma, this writ petition is taken up for disposal at the admission stage, full stop para. The petitioners
Paragraph 4, my lord.
are residents of various villages in the district of Nimahasab. Full stop. The projected case of the petitioner is due to the construction of the Assam Mala, Assam, MALLA, within bracket 2-lane highway, comma, lands of the petitioners were adversely affected and there was no verification, public assessment of the loss. Full stop. The petitioners had accordingly approached this court for with a direction that proper assessment be done of the loss suffered and damages be paid to them in accordance with law. Full stop. Sri Barua, the learned counsel for the petitioner has however fairly submitted that in the affidavit in opposition filed by the authorities of the NCHAC dated 8/12/2022, it has been stated that re-verification is being done in the over the land in question, which was and whereafter, comma, appropriate steps would be taken. Full stop. Sarah. Sri Sharma, the learned standing council, NCHEC.
Not the standing.
Huh?
I'm not
Oh.
standing.
Learned council appearing on behalf of the NCHEC while endorsing the submission of the made on behalf of the petitioner submits that in the affidavit mentioned above, dated 8/12/2022, comma, the aforesaid averment has been made in paragraph 7 and 8, which are extracted herein below. Full stop. Sarah. Sri Barua, the learned counsel for the petitioners, accordingly submits that in view of such statements, comma, the relief claimed can be modified to the extent that the re-verification exercise be concluded expeditiously and the outcome of the same be communicated to the petitioner. Full stop. Para. In view of the aforesaid facts and circumstances, comma, the instant writ petition is disposed of by directing the response number 4
Yes.
to complete the re-verification exercise expeditiously and preferably within a period of 2 months from today, and thereafter communicate its outcome to the petitioners and other affected persons. Full stop. Para. The assessment of loss, comma, if arrived at, and in case, and the reparation account is established. Yes, next.
So in case any consequences should follow, my lord, if the land.
It is needless to say that based on the re-verification exercise, comma, the necessary consequences are required to be followed in accordance with law.
Earlier place. My lord, similar item 37, same village, same petition.
Paragraph,
Paragraph also same, my lord. They are
your file, date of filing the affidavit. 8/11.
On my lord, I received on January 2023, 30 January,
You need the official date.
same affidavit, my lord.
Array of parties, same manner.
Yes, sir. Yes, my lord. There are 9 and 10, my lord.
Devendra Kapoor.
9, 8 and 9. 8 and 9 of.
यहाँ paragraph 8 and 9 हो. In opposition 1/2/2023. 1/2 1/2/2023. 1/2/2023.
Item number 37.
Party number
37.
37. Affidavit in opposition 1/2/2023. Yes, next.
Acknowledgement.
8 and 9. Put कर दीजिए. 7 and 8.
Obligation.
They are also the State Council and Revenue Department.
Same party.
What is in this proposal? I hope.
Definitely, the lordship. Lordship, our matter is relating to non-payment of victim compensation amount, lordship. Lordship, last operations, lordship, the affidavit has been filed, lordship, by the DLCA. In this affidavit.
Yes,
Sorry,
madam.
Lordship, here, it is interim compensations, lordship. And I am seeking a compensation pursuant to a notification, lordship.
How much is your entitlement?
10 lakh, it is 8 lakhs, lordship.
8 lakhs. Madam.
Who is? Who is?
Is it pursuant to some court's order? No. Court has not granted, it's not in accordance with some judgment. Is it a part of some judgment?
No.
Or independently by the, under the scheme?
Yes,
How do you overcome?
Lordship, what happened, Lordship, as per the APC, it's deals Lordship. If a trial has not been concluded, a person can be applied for seeking compensation, Lordship. And there is a policy of the state government, Lordship.
Still, Madam is referring to the policy only. The scheme gives you 6 months.
Lordship, here, Lordship.
You
it's-
filed your affidavit. You have filed. Who has filed? Who is responsible 3? You have filed already. Madam, you also file your affidavit. You are raising this point of limitation. Let it be on record. Okay. If we do not accept, then it's a different matter, but if we accept, it has to be on record. Do affidavit in opposition has been filed by the Asalsa.
Yes,
Madam Chaudhary Asalsa. Asalsa or DLSA? No, you're appealing from. The affidavit has been filed by Asalsa dated 27/2/2023, which is represented by MS R.S. Chaudhary, MS. An objection on the ground of limitation has been raised by MS S. Sharma, the London State Council. That is said objection be there by way of an affidavit, which may be filed within a period of 3 weeks from today.
highly appreciated. Here, Lordship, it is a non-payment of compensation amount in respect to the land acquisition. Lordship, land has been acquired in the year 2019, Lordship.
2019.
19, Lordship. Award has been passed and a notice was issued to the present petitioner's Lordship.
Yes, why haven't you paid the compensation?
Accordingly, Lordship.
2,69,000.
Yes, Lordship. And I have submitted my representation on 25 March 2020.
Any instructions, madam? Get the instructions. The matter relates to non-payment of amount pertaining to acquisition of land, full stop para. MS Sharma, London State Council prays for and is granted 4 weeks time to obtain instruction, / file an opposition. List after 4 weeks.
Highly appreciated.
Mr. Ahmed, which matter are you waiting for? Huh? 38, okay, one more matter.
May I please, your lordship, non-payment of dependent to freedom fighters pension miller. Petitioner is the daughter of a freedom fighter. She has been getting state pool, but she's not getting central pool. That is why last affidavit was required.
Madam?
As per my instruction, process, he has not applied to the municipal pension. Is as per the guideline, it to be applied for transfer of the.
Where is your application?
Yeah, here, my lord. After this, your lordship may peruse now. Order after break of this. Page.
And also her name was not mentioned in the original application by her father for the freedom fighter. 4 daughters' name been mentioned in the application. Her name is not in the.
No, then.
You have stated this on affidavit.
No.
It is in section.
You file your affidavit.
Fine.
Let him have a fair chance of replying to your government. On the pair of MSRDV, London CGC. Matter stands adjourned by 3 weeks to enable filing of an affidavit, filing of the affidavit in opposition. 3 weeks.
Oblige.
arbitration. Affidavit filed today.
Yes, Lord.
Are you objecting to this?
I received the affidavit today itself.
Okay.
Week's time may be granted to go.
Are you objecting or what?
A week's time may be granted to go.
I'm objecting.
You're for the respondent, aren't you? You have filed the affidavit today. Are you objecting to the?
Yeah.
Yes. Why?
Maintain the condition for the work was to deposit the earnest money. Only 50% was deposited.
No, they are only asking for a dispute redressal mechanism, appointment of an arbitrator, isn't it?
Yes.
You don't, as per you, it's not,
Not arbitrable.
is it? Where have you stated?
Paragraph 16.
Sixteen.
16 and 20 also.
Termination of the contract cannot be a matter of arbitration.
Our submission is not.
No, but there are decisions that in spite of the fact that the clause is a part of the contract, termination of the contract will not make the clause nugatory. It will be still in force. Okay, we'll hear the other side.
Let him give the.
You'd like to have your response.
Lordship will, yes, will file reply.
Your name, what is your name?
A Barbusari.
Heard Sri Borpur, the elected counsel for the petitioner. Also heard Sri M. J. Damed, senior counsel, assisted by Sri A. M. Datta for the respondent who has filed an affidavit in opposition today. Full stop. The senior counsel for the respondent has raised an objection with regard to the prayer for referring the matter to arbitration. Full stop para. On the prayer of the Borpujari learned counsel for the petition, a matter stands adjourned by 3 weeks to enable him to obtain instructions, public file affidavit, file rejoinder affidavit. Yes. Next. Arbitration, again. Yes.
May it please your lordship.
Yes, Mr.
In this case, I have instruction. I will file affidavit.
Objecting.
So we are objecting of
Right.
as per the GCC laws.
It is not arbitrable or what?
No, my lord. The issue is,
Conflict is there, lordship. And his other bench honorable apex court says that, lordship, we can do for our GCC lordship. After that, conflict communication is there, lordship, is that, lordship. No, as per the amendment provision of 12(5) law. Now it is pending before a larger bench for consideration.
On the issue of appointment of arbitrator.
Appointment.
Lordship, appointment of-
actually, my lord, what the issue is very interesting, my lord. After the amendment section, if you lordship to kindly have the arbitration act. Section 12(5).
Arbitration. AA. Yes.
Subsection 5 of section 12, my lord.
Yes, please. Yes, please.
Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or subject matter of the dispute falls under any of the categories specified in 7 schedule shall be ineligible to be appointed as an arbiter. That means, my lord, now under the agreement, it is the general manager who is to appoint. Now, since he himself has been incapacitated, where is the question of he having the power? Now, schedule 6 and 7, my lord.
That means the entire concept of internal arbitrator perhaps would be,
Yes.
would not
Sought to be done away with.
would not stand in view of the amended
Yes.
insertion of
Now,
5.
what had happened, my lord, if your lordship would kindly come to page 16 of the petition, my lord.
Hmm.
Kindly see page 16 of my petition.
Yes.
I'm reading the subpara, my lord.
Hmm.
Under clause 5 and 12 of the 7th schedule, any person who is a manager of a party to an arbitration and exercises controlling influence or is a part of the management of a party to an arbitration is also disqualified from acting as an arbitrator.
Hmm.
The Supreme Court of India in numerous decisions has made it crystal clear that a person who is ineligible to act as an arbitrator under section 12(5), read with 7th schedule of the Act, is also ineligible to appoint an arbitrator. In other words, if a person is disqualified from arbitrating a dispute, disqualification also extends to their power of nominating and the person as an arbitrator.
Correct.
Now, my lord, in these cases, my lord, the view has been taken, it cannot be. Now, in one case.
This is quotation from which, what?
My lord,
This is a part of this quotation, is quotation from what?
it's not quotation, my lord. It's the submission, my lord.
Of, in what, which case?
In this, no, my lord, we are referring to different Supreme Court cases, my lord.
No, no, this,
It's not a quotation from any judgment. This is the statement we have made, my lord.
why italic then?
Italics just to draw highlight attention of the court, my lord.
We are looking for the quotation marks.
I know.
Those are not
Even-
there.
Even, my lord, anyway, my lord. So, my lord, these are the judgments where the Supreme Court has taken the view that no, yes, but they are incapacitated. But in one judgment of the Supreme Court, my lord, that is 20, where it was said there is no bar.
Name.
Central Organization
Ah.
for Railways
Ah.
Electric Chamber.
There the honorable three-judge bench of the honorable Supreme Court says, my lord, that it can be. My lord, this has been referred to a larger bench.
Okay.
No, it's a Tantier.
It says that, Lordship, as per the amendment of 12(5) will be.
Kindly see, my lord, having heard Mr. So-and-so, it is clear that on the facts of this case, judgment of the High Court cannot be faulted with. Accordingly, special leave petition is, however, reliance has been placed upon a recent three-judge judgment. This is the judgment, my lord. In Central Organization for Railway Electrification, a joint venture reported in so-and-so. We have perused the aforesaid judgment and prima facie disagree with it for the basic reason that once appointing authority itself is incapacitated from referring the matter to arbitration, it does not then follow that notwithstanding this, yet appointments may be made valid depending on the facts of each. The judge of judges now has disagreed and therefore it is referred. এটুকু তো রেফার করছি
লাগাৰ বেঞ্চত ল'ব লাগে বুলি কৈছে। ইয়াৰ ভিউটো দিছে তাকো আপোনাৰ JSW আছে ভিউটো কান্তি আৰু ইটলি
It's a কথা, same thing. So, my lord, that the statutory mandate is capacitated. Now, by a judicial interpretation, that was sought to be settled not by. Therefore, my lord, what we suggested the name of a retired judge of this honorable court. Lordship, you kindly see the order while issuing notice to respond to that.
Lordship, I will already receive it, I will file it. And after that, Kantia Lordship, JSW Lordship Limited, the Southern Railways, before I will attach to concerning. Considering the view Lordship,
Change to the London Senior Council for the petitioner. Full stop. Also heard, also heard Sri K. Gogoi Leonard CCC appearing for the railways. Full stop. Sri Gogoi, the Leonard Council, after that instructions have been received,
Yes.
based upon which he would be filing an affidavit for which he has paid for he has paid for and is granted 3 weeks time,
Lordship,
3 weeks time. Pay for it, we fix a date or what?
My lord, Lordship may fix a date after 3 weeks.
probably of the next week, Ladder bench will sit regarding this. After 3 weeks, Lordship, in the meantime, if any result come, we will test it.
Lordship may kindly fix a
No,
date after 3
No, no, wait. Since this court has been apprised that the issue involving in this case regarding appointment of arbitrator is presently under consideration in the Honorable Supreme Court, parties are given liberty to make a mention for taking this matter if the need arises.
This matter pertains to non-payment of contractual bill. Affidavit has not been filed.
PHE,
If extra copies were not served. So we think
extra copies.
the copy- I will do that, Lord.
Madam, you are for? Who is one?
Commissioner and Secretary, PHE.
And madam, you for? Who is two?
Sabian Long Autonomous Company.
Your KSC. Your madam extra copies given to you or not? No. It appears that extra copies of this writ petition have not been furnished to the learned counsel for the respondents. Full stop para. Sri Ganguly, learned counsel for the petitioner undertakes to serve extra copies to the learned counsel for the respondents by tomorrow. List after 3 weeks to enable the respondents to obtain instruction. To enable the learned counsel for this.
In this case, government has finished and filed their affidavit.
Hmm?
Government has finished and filed their affidavit.
These matters, I will respond in first one. The others also there. Fairly connected with the particular fisheries. That with the market. Will also like to file an affidavit.
How much time?
A week's time.
Though the department has filed the affidavit in opposition, if private respond. You said it has been filed?
No, ma'am. They
Oh,
shall
yeah.
not file their.
Oh, none of you have filed. Okay, okay. It appears that none of the respondents have filed the affidavit. List after 3 weeks to enable the respondents to file the affidavit.
That's a interim order may be.
There are interim order passed a day to continue till the next day of listing.
Anak council. Leave the court. K.K. Gupta.
Some other day,
Lordship.
madam, Woodlord, revenue. File affidavit, no.
No, not at all.
Hmm?
We have to sit our answer.
While the state, while instructions have been received by, by the state council, Rishikesh Barua, Barua, no such instructions have been, the instructions are yet to be received by MSN Bodloy, Standing Council Revenue Department, full stop para. List after 3 weeks to enable the respondents to obtain instructions, file affidavit in opposition.
This matter.
Can be passed over for timing.
5-0.
Yes, Lord.
Already 4:10. The last occasion, a submission was made from the petitioner's side that the NOC, which we had produced and it was for residential building, they made a submission that it was for another, they have their,
Yes, yes,
yes, so they only have to
that
produce a document.
stop,
Yes, your lordship.
that you said it's another.
Yes, they said that it's another building. Pursuant to your lordship's directions, we have conditionally renewed their license. So, but if they do not produce it, that means they will in effect be running a wine shop in a residential building.
Yes, where is it? Left day after tomorrow,
Very good. But can it be on Tuesday, your lordship, day after tomorrow?
Friday? No,
Friday, I was.
Tuesday, okay. Prayer for adjournment has been made on behalf of the petitioner. Para,
Tuesday 4th.
considering the subject matter, comma, list on. It will be second, I think, second of.
Deeply okay.
Lordship, interim order passed earlier, maybe continue.
There are interim order passed earlier to hence extended till the next date of listing. Fifty-one, Mr. Ken Chaudhary. Ken Chaudhary, his chamber juniors, colleagues.
Also, his tender, his case was terminated, lordship, and thereafter subsequent tenders were issued, lordship. Last date, lordship, direction was issued to produce records. Records are with me. And interim order was passed not to finalize the tender till the next.
Okay. You have the records.
Yes, lord.
There is an interim order, they should be present. We'll have day after tomorrow. None appears for the petitioner on call. On the other hand, Sri P. Nayak, Leonard, Planning Council, PWD, submits that pursuant to the earlier order dated 10/4/2023, comma, he has produced the records. Full stop. He has also apprised this court that an interim order is in operation pursuant to which the new tender process is on halt. Mr. Para,
I'm sorry, lordship, actually my senior was just going, I was about to go.
yes, we were asking for his name, you are not appearing. It's 11 day after tomorrow.
Okay, okay.
A prayer for adjournment is made on behalf of Sri Ken Chaudhary Senior Council. So, ekhini pura likhiba. On halt, last one. In the interest of justice, list again. After tomorrow.
For the interim to continue.
Interim order passed earlier to continue to the next day of list. Okay, admission, make. Last one. Vijay Mukherjee, R. Saha. Usami, you are for whom? Transport Department. None appears for the petitioner on call. Whereas what High Court? You for whom? Higher. Whereas the Guwahati High Court, as well as the Transport Department is represented. Post of para in the interest of justice, list after a week. What is normally called? What is the main order?
Sir, 52 and 53, our two aircraft shop licenses have been cancelled at the instance of MLA, my lord.
What license?
Aircraft shop license. So, my lord, we are four ladies, widows. And since 15
Affidavit
years,
filed.
my lord,
What is your
we
stand?
have some urgency, my lord.
We'll have it next Tuesday for disposal. What is your stand? Is it at the instance of some MLA?
Yes, on record, we are 70.
Tuesday.
For disposal.
65.